Peace to the gods, Yusufel here. All right, y'all, how's everybody doing today? Get ready for another episode. My name is Yusufel. I'm the creator of SPC University, High Frequency Radio, and I am a staunch defender of private property rights. Today, I got an interesting show for you. This show is a result of a comment that was at the bottom of one of my videos, and I kind of took it as a challenge. And it seems to be like a comment from someone from the legal community. However, you know how that goes. You know, you go to their page, and it's some fake page. It looks like somebody who is going at anti-sovereigns. And I'll get right to it. I'll get right to it. This is the comment right here. An individual who was claiming that I didn't know what I'm talking about. You know, I'm a layman and I don't understand this information, you know, blah, 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 blah. You know, the typical thing that they say. And then basically, let's read it right quick. It says, "It is clear this gentleman does not comprehend the concept of federalism under which the U.S. operates." Note he said the U.S., not the United States of America. Article 3 courts are federal courts, and Article 1 courts are limited to D.C. and federal enclaves, which is true. They're territorial courts. He doesn't seem to understand federalism, and I'm going to try to explain it to you, okay? State courts are established under the 10th Amendment. He also lacks knowledge of jurisdiction. He doesn't seem to know that Louisiana is the only state whose law is not based off common law. It's a Napoleonic code. Everybody knows that. You know, Louisiana was the last state to adopt the UCC. Yes, I'm very familiar with that. I don't even understand what you're talking about. I don't understand why you even brought up Louisiana. All right, but I understand Louisiana. It was a French territory. But let's get into some of these discussions of what he's saying. He also went on to say, so I got into a discussion with him, and I asked him, you know, he said he's won a case. I said, okay. He said he's won a case. All right. So I go in and I said, all right, well, all right. It appears you don't grasp what constitutes arguing cases. Yes, I do, because we don't argue cases. That is the domain of attorneys. If you've been watching me for any appreciable amount of time, you know I urgently discourage any of my listeners from arguing at all. We are about acceptance for value on this channel. I know you don't understand anything that has to do with this subject matter because you get all of your information from, you know, the Southern Poverty Law Center or some blog on some liberal website or some Marxist communist website. You have a typical mindset that I see. So he gave me some of the case laws allegedly that I don't know if he argued them or not. He doesn't seem to claim to have argued them. He said he won the case. I'm not sure what it was, but these are gun possession cases in a school, and which I found very interesting. Let me see if I can bring some other. Yes, this is it right here. Peace to the gods, Yusufel here. All right. So, you know, this was under the last video. This is the original conversation right here. There's the guy. And when you click on, and what I always do, I always click on their picture and look at their profile. And it used to have a thing on here where you could check to see if they had a Facebook profile or social media, but they've changed all that since people caught on to a lot of things. And what's really interesting, if you ever want to block a person, y'all know that to block them, that you simply click on their picture and you go to the about section or something, like get in their name, and and then you can block them. It doesn't look like I can block him though. Here's his video. So, okay, you can see that he is an individual that is heavily invested in disparaging any of this information. Penn Hollow quoted by sovereign citizen is bogus. New sovereign citizen tries unique defense. Another Michigan. I'm going to make sure I'm going to make a point to review a lot of these videos. This is going to be my source for a little while. Another Michigan sovereign citizen gets his motion to dismiss explained and denied. Galt Schools, BSBT, and Wolverine Transparency. Look at this person. He's expending a lot of energy going in on what they term as sovereign citizens, which is disrespectful. That's basically like calling you niggas. Now, these type of individuals, these are communists, Marxists, and you need to start labeling them what they are. Okay, they are heavily invested against anything that's dealing with the republic, these are just people for the New World Order, which is why you never see their true identity. All right, they're working behind the scenes to perpetuate, to basically make all this look crazy. Sovereign citizen pseudo lawyer Mark Stevens. He's attacking this individual. Mark Stevens has been around a long. He's got adventures in legal land. If you ever gotten his book, he seems to have spent a lot of time concentrating on Mark Stevens. And bullshit meter, you can see all of it right here. Bullshit. Sovereign citizen pseudo lawyer Mark Stevens, unsigned guilty plea bullshit. What I want you to do is I want you to look at these individuals. I don't ever discourage anyone from watching these videos because you need to learn their techniques. You need to learn their techniques, and you need to see what it is they're saying and what it is that they're not saying. You got to be able to learn that determination. So right here, you can see right here, this guy, he has, I don't know, it's like, this is his home right here. These are the channels, his community. He don't have any playlists, but he just got videos over here. And that's it. He said, a constitutional law attorney of 40 years debunks internet pseudo-lawyer bullshit. All right, so that's his channel, what his channel is devoted to. I'm really interested. He got 6,000 subscribers, but so he's not making much of an impact on anything. But all right, let's look and see what he gave me. He gave me these citations of authority, and as you can see right here, once again, if you're just joining me, and let's see if I can. And let's get the likes up, y'all. Let's get the likes up to 100. Let's get the likes up. And the website is running fine. I figured out why it was running slow, and I got my hosting company to make a correction in it. So the website should have sped up significantly. You'll notice a difference in the speed of the website. Let's get into this real quick. Now, to begin with, I want to, I'm gonna try to make this a teaching, and this is going to be very in-depth. So I want everybody to pay attention as we go. All right. Where did I just put this? Okay. All right. So to begin with, okay, this is SBC University. This is my website. This is free information. Anybody can come to the website and get this information. You do not have to be a member of SBC University to access any of the information that I'm showing you. Just go right to the website, go to the PDF downloads, and it's available for you. Because all this information is readily available on the internet anyway. But it's just that I'm just putting it in one area for you, make it convenient for you to download. All right, so right here, first and foremost, I want to direct your attention to analysis and interpretation of the Constitution. We want to stay right there. The Constitution of the United States, analysis and interpretation, annotation of cases decided by the Supreme Court of the United States to June 29th, 1992. And they have different versions of this. You can go to their website, and they have updated versions of this as well. However, what I want to bring your attention to is the introduction of this. And I'm just going to get right to it. Okay. So right here, you can see, and this is in the introduction to the 1992 edition, I want to bring your attention to this. National federalism as a doctrine was proved to be far more pervasive and encompassing than it was possible to notice in 1953. In some respects, of course, later cases only confirmed what those decisions already on the books told. Foremost example of this confirmation has been the enlargement of national powers, of congressional powers under the Commerce Clause. Now, in here, I want you to tell you, they're going to spend a lot of time discussing the Commerce Clause. The Commerce Clause is responsible for more litigation in the federal courts than any of the clause in the Constitution that comes from this document. Additionally, the cases in which he submitted to me are surrounding the Commerce Clause in the 14th Amendment, and whether or not there's some economic application of the conduct that was alleged in the particular case. Did it relate to interstate commerce? And did it materially affect interstate commerce in some kind of way? That is what they have done. They've converted all, and this is what we've been saying. And this is what was really interesting about this case that he gave to me. I'm like, do you not understand what it is that we're saying? And I thought it would be an interesting case to review since he gave it to me. But this is dealing with the Interstate Commerce Clause. I had a case in federal prison where a young man, he's probably about 17, 18 years old. He called a federal case. He was caught in a hotel room with his girlfriend. Now, he was a small-time drug dealer. This guy was not no big-time. That's why I don't like the drug laws. They were supposed to get the big drug dealers, but all they've been doing is rounding up a whole bunch of nickel and dime ass people because they're involved in slavery. We all know what's really going on. They really don't have any interest, really, of catching the big individuals, because if you were, you'd be looking at the CIA and the people who are responsible for distributing all of this cocaine and everything in our neighborhoods. But you're not interested in that. Once again, go back and listen to Rabbi Finkelstein as he discusses that. All right, but right here, once again, the young man, he got caught in a hotel room, and he had a gun, and he had probably about, some baggies of some dope or something like that. I didn't understand how the case was federal. He had never been out of his city before. He wasn't a big-time drug dealer, and he was just caught in a hotel room. And he came to me for help, and I'm reading his case, and I'm trying. And anytime I get a discovery, the first thing I'm looking for is the jurisdictional element that granted the government the jurisdiction to have over the case. 90% of the time, it's something involving interstate commerce. 90% of the time, and I can show you all of this. And I was looking for that, and sure enough, it was interstate commerce, but I still say, well, what did he do? And it was because the gun had been manufactured in Baltimore, and it went across state lines into Florida, and that is how the government got jurisdiction over the case. All right, now, I'm telling you all this because I'm preferencing when we read this case, I want you to see all of this, and now when you look at the case, it's going to give you some insight into why the judges decided the way that they did, who, dissenting opinions, concurring opinions, and things like that. And it also gives you some insight into the minds of the judges. All Supreme Court judges are not the same. Some are originalists, meaning that they apply the meaning of the Constitution in its spirit and the original intent that the framers had for it. And then you got some who construe it as a living document, that it changes with the time. And most of the time, the Supreme Court justices who interpret the Constitution that way are liberals. They are Democrats, all right? So you need to understand this and go investigate everything I'm saying for yourself. So let's read this again. It says, national federalism as a doctrine was proved to be far more pervasive and encompassing than it was possible to notice in 1953. In some respects, of course, later cases only confirm what those decisions already on the books told. foremost example of this confirmation was been the enlargement of national powers, of congressional powers under the Commerce Clause. The expansive reading of that clause's authorization to Congress to reach many local incidents of business and production already apparent by 1953 was scarcely enlarged by those decisions of the period through the 1960s, through the 1980s. And this right here, as you can see, the expansive reading. They have a very expansive reading of the Commerce Clause. It encompasses a lot. We're going to talk about 27 Code of Federal Regulations 72.11 after this as well, under which Congress asserted jurisdiction on the basis of an antecedent or subsequent movement over a state boundary of some element touching upon the transaction or solely upon the premises certain transactions by their nature alone or as a part of a class sufficiently affect interstate commerce as to warrant national regulation. That is the key to everything that we're talking about right here. This is it. This is what you have to understand. This is how they obtain jurisdiction in commercial matters, all right? Under which Congress asserted jurisdiction on the basis of an antecedent, a subsequent movement over a state boundary of some element touching upon the transaction or solely upon the premises certain transactions by their nature alone or as a part of a class sufficiently affect interstate commerce as to warrant national regulations. Now we're talking about transactions. Also, I want you to key in on that. Civil rights laws touching public accommodations and housing, environmental laws affecting land use regulation, criminal law coverage. They didn't give any, they didn't narrow that down, but it also involves criminal law coverage. Right here, they're admitting it. Commerce, criminal law coverage, and employment regulations touching health and safety as well as benefits are only the leading examples of enhanced federal activity. Okay, so this next sentence is something that you need to pay attention to too. Let's read it again. Civil rights laws touching public accommodations and housing, environmental laws affecting land use regulation, criminal law coverage. Now, this is what you're going to see. You're going to notice that they are intentionally vague in certain aspects. And also in this book, when we look at Article 9, Article 1, Section 8, Clause 9, and compare it to Article 1, Section 8, Clause 3, okay, they intentionally get vague. Almost every law book that I've looked into, there's no clear explanation on exactly what Article 1 courts are. And before I go into this, I'm going to look. This book right here has a cornucopia of information, and you should go to this book and get you a foundational understanding of all the information that we're talking about. It is available on SBC University. It is available readily, freely on the internet. You can find it, okay? So let's go and look. It says, conversely, state power to regulate commerce has been further restricted through the application of a doctrine of preemption, which is increasingly aimed at one national standard. Okay, they're moving toward a new world order. They're going to unify the laws nationally, and then they're going to unify all of them worldwide. Okay, although under Chief Justice Berger and Chief Justice Rehnquist, the court has not so readily as before seemed to favor preemption, and Rehnquist did take some exception to all of this, especially in the area of labor management relations. I'll notice all this is commercial. Only with respect to the state's own employees did the court inhibit federal regulation, and then with a decision which failed to secure a stable place in the doctrine of federalism being overruled in less than a decade. Some immunity for states from federal laws aimed directly at them was implied from the Constitution, but its potency remains to be seen. All right, noteworthy. In other words, they have successfully, and the reason for that is because they're bankrupt. They're all using Federal Reserve notes. Let's just get it real. We're not operating in a constitutional republic anymore. A democracy is dramatically different than a constitutional republic. And this is what this gentleman who is an attorney, he doesn't seem to understand what has materially changed since 1933. Since the Erie versus Tompkins Railroad decision. You're an attorney, you learned that in law school. Okay, what has materially changed in the United States? What is the effect of there not being any money, of the bankruptcy of the United States and the New Deal and the issuance of Social Security numbers? Are you trying to tell me that that doesn't matter, that that has no signification whatsoever? You are claiming that you've been an attorney for 40 years, which doesn't mean anything to me. You could be doing this for 40 years and still be a fool. All right, so let's look at this. Let's look at this. Let's go deep. Let's go deeper. All right. It says, Okay, so we read all this. All right, so we just went into the commerce clause a little bit, and that's just the introduction. Let me get into this real quick and show you, because I love this document. I want to just bring your attention to something. It has the Constitution in the beginning, and then it breaks down and has a discussion about every amendment, every article of the Constitution. That's what I like about this document. So if we go in here and we look at proposed amendments, this is the legislative department, legislative powers. This section 2. Okay, here, Article 1, Section 8, Clause 1. This is taxation, regulate commerce. And this is what we really need to get this, but I want to show you this real quick. And you see how long the commerce is. The commerce section go on forever. Look, we still talking about regulate commerce. I mean, it goes on forever. Look at this, still talking about commerce. Section 3. Y'all need to check it out. So now we get the clauses 5 and 6, fiscal money, copyright, 9, 8. All right, so here's 9. So when we get to 9, this is 9 right here. Copyright and patents, and 8 clauses 9 and 10. So here's 9. Congress shall have the power to constitute tribunals inferior to the Supreme Court. See Article 3. Notice it puts see Article 3. Okay, so that's it. It don't have nothing else under that. It is the only thing in this book. They say see Article 3. Okay, well, we know by separation of powers doctrine that an Article 1 court cannot exercise the same, and please don't make me do a whole entire show on that. Please don't make me, some things you should just go on and agree to, but a lot of times these guys, they're gonna make you go and show and prove that you know what you're talking about, which is why I go to such lengths in doing all of this. So right here through this whole book, this is the only one in the whole book, when you get to Article 1, Section 8, Clause 9, it don't give you no explanation. It says, see Article 3. Well, we know that Article 3 is the judiciary, so this is what they're implying right here. So when you go to Article 3, this is what they want you to believe. Article 3, Judicial Department. All right, so inferior courts. All right, now, so we get into here. This is Article 3, Judicial Department. So here's where they have a discussion of inferior courts. Congress has also acted in the Judiciary Act of 1789. Now, an act is a statute, okay? They are enacting statutes to create courts under the legislative branch of government because the Constitution for the United States of America delegated the power to them to do so. But we're discussing it under Article 3 because the Supreme Court justices, they are the justices, are talking about this. But let's go. It says, to create inferior courts. 13 district courts were constituted. Okay, so you got the U.S. District Court and you have the District Court of the United States. Just like you have the U.S. Supreme Court and you have the Supreme Court of the United States of America. There's a distinction between the two. All right. 13 district courts were constituted to have 4 sessions annually, and 3 circuit courts were established to consist jointly of 2 Supreme Court justices each. And notice they put Supreme Court in all capital letters. Supreme Court justices, each and one of the district judges of such districts, which were to meet twice annually in the various districts comprising the circuit. This system had substantial faults in operation, not the least of which was the burden imposed on the justices, who were required to travel thousands of miles each year under bad conditions. Despite numerous efforts to change the system, it persisted except for one brief period until 1981, which doesn't mean anything to me. All this right here, it doesn't even mean anything. Okay, compensation, diminution of salaries. The compensation clause has its roots in the long-standing Anglo-American tradition of an independent judiciary. A judiciary free from the control by the executive and the legislative is essential if there is a right to have claims decided by judges who are free from potential domination by other branches of government. This is key. This is what distinguishes an Article III judge from an Article I judge. Okay, protection from salary diminution, as well as lifetime, as a lifetime term. Okay, because there's separation of powers. You gotta always remember this. You gotta remember separation of powers, because they're giving you the impression that there's some similarity between an Article I and an Article III court. An Article I court cannot be a court of justice. It cannot be a true judiciary, a true judicial court. It may be exercising judicial powers, but it's only exercising judicial powers under the cognizance of the subject matter that is being involved in the case, which in most times is commercial in nature. So it's administrative in nature. The judges are administrators. They're administrative law judges. They're administrating something for the legislature. And the Supreme Court of the United States of America acts in an appellate capacity to that by reviewing the decisions to ensure there are no constitutional violations. Once you understand how everything is set up, you know, it's very easy to see how that's the first thing you gotta get clear in your mind. How is all of this set up? What is the relationship between an Article I court and an Article III court? They intentionally make this obscure. This one point right here where a lot of people are having a trouble, and this is why you got to do a deep dive in this particular subject right here. This needs to be a focus and concentration on anyone who's seriously doing study or seriously about this information and you're going in court. This is where the ignorance of the American people is at its largest, in my opinion, is people don't understand how everything is set up, and they're not trying to explain it to you. They're not trying to explain it to you. All right, so right here, when we get into this, I want y'all to pay attention to this right here. Now, this is right here. It says, upon a receipt of a letter from President Washington soliciting suggestions regarding the judicial system, writings of George Washington, okay, J. Fitzpatrick, and Chief Justice Jay prepared a letter for the approval of the other justices, declining to comment on the policy questions, but raising several issues of constitutionality, that the same man should not be appointed to two offices, that the offices are incompatible, and the act invaded the prerogative of the president and the Senate. The Senate is the head of the legislative branch, and the president is the head of the executive branch. Okay, so we're talking about separation of powers. This justice understands this. So when you go back and you look at this right here, this video is called The Role of the Supreme Court Okay, when we look at this right here, Scalia and Breyer, they are in a judiciary committee before the Senate. The Senate creates this committee to talk to the Article III judges about what is constitutional and what is not, will be, like they call, struck down, and what won't be. Okay, they get into discussion about what I just read about Justice John Jay not wanting to comment on something, and Breyer was saying, well, he didn't know the answer to it. And of course, his senator, he said, well, his tenure was short-lived. You could tell that they didn't like Justice John Jay. Why? Because he asked the same question that we're asking today. Okay, under the analysis and interpretation of the Constitution, we're asking the same question. Okay, that the same, right here, Chief Justice Jay, right here, I prepared a letter for the approval of the other justices, declining to comment on the policy questions, but raising several issues of constitutionality, that the same man should not be appointed to two offices, that the offices were incompatible. Well, we know we have the doctrine of delegation of powers doctrine, that the legislature can delegate powers to Article 2 and Article 3 judges. We can look at this right here, delegation of powers doctrine. And this is what Scalia got into too. He says there is no he said unconstitutional delegation of powers. He said there isn't any unconstitutional delegation of powers because there's no constitutional delegation of powers. You can understand why he came up missing, because he was exposing some things. He was a good justice. So we got what is called delegation of legislative and we got Article 3, legislative courts adjudicating public rights. Legislative courts right here. Okay, the judicial power. The Supreme Court has held that Article 1 courts can adjudicate cases involving public rights, because that's what they are, cases that rise between a private actor and the government. That's what public law is. The public rights theory can be traced back to the court's 1855 ruling in Murray-Lessee versus Hoboken Land and Improvement, another commercial case. It's a company. We're dealing with corporations once again. I've read all of this before. I'm just giving you something so you can go in and do your research. You also should go into an American jurisprudence and study everything under administrative law. It'll be very, very eye-opening to you, because these are administrative agencies that are bringing claims against you, okay, in your public capacity. All right, so I'm giving you this ain't no sovereign citizen stuff I'm giving you. I'm giving you their stuff to read. Read their stuff. Read all of their stuff, because they are telling the truth. Is sometimes the language is so transcendent, it's beyond ordinary capacities, and you don't understand it. They don't think you would ever read anything like this, which is another reason why this guy gave me he gave me this his case law. You don't think you're gonna read it. You don't think you're gonna read it. You don't think you're gonna read it. That's what it is. All right, sure, I'll give it to him. He's not gonna fucking read it. All right, so let me get back. So I want you to download Supreme Court Analysis and Interpretation. I want you to get that. I want you to start grasping and getting into understanding of what commerce is, the pervasiveness of the Commerce Clause, because that's what's going to be discussed in the cases that he has sent to me and the 14th Amendment. Okay, and he said he argued this case. He says, excellent, Yusuf. Thank you for this point. Why fellow Americans so illiterate? It's why the public is exposed to public bullying. Thank you, Yusuf. Our study group won't throw out the baby with the bathwater. Okay, with the bathroom. Ever since the pandemic, he's been trying to get everyone evaluated. They've been trying to get everyone evaluated. Okay. Let's get into this. All right. So I don't want to get off track. Okay, so we just did a cursory investigation and analysis and interpretation of the Constitution. We understand that we have to understand the doctrine of separation of powers. That is something you have to understand, that a legislative court can never exercise true judicial powers. They exercise, not that it's been delegated by the Constitution, not constitutional authority, only within the delegation of powers that have been delegated to them under Article 1, Section 8. They can adjudicate any of that, okay? That is what they have cognizance over. However, the territories belong exclusively to them, and they exercise plenary power within those territories, which means they're like God within that territory. There are no constitutional limitations. And we have been made a part of that by becoming a U.S. citizen. That's what a federal citizenship is. Now, do I have to get the case law for that too, man? They got case law for that. I got to dig all this stuff back up. Please don't make me do it, because I only read case law. I'm going to locate the case law and show you that. A U.S. citizen is a federal citizenship. You should know that. If you're worth your weight in anything as an attorney, you should know that. That there was no U.S. citizenship prior to the 14th Amendment. All right, so, and that was as a result of the Dred Scott decision that they made the 13th, 14th, and 15th Amendment, the War Amendments. All right, so once again, all right, so we just got, and this Susan B. Anthony versus the United States is on here. And the special maritime jurisdiction exposed is something that you should, it is replete with case law as well, talking about the admiralty jurisdiction that is being exercised by the courts. Case law. You got to get, if you're going to deal with these people, you got to get in there reading case law. If you follow the guru and he don't know how to read case law, he doesn't know what the fuck is happening. He don't know what's going on. All right, you got to read this stuff and get into reading this stuff to see what they're talking about, because most of their assumption and presumption is based off the fact that you won't even pick it up and read it. And then following that is if you do read it, you won't understand it. And it's not difficult to understand. This shit is not difficult. They be trying to act like they fucking super geniuses or some shit like that. Most of these motherfuckers didn't even want to practice law. Their parents made them go to law school. They didn't fucking want to go. Yeah, you have to be bright to understand it, but not that goddamn bright. This ain't rocket science. You understand a few principles, and it organizes your thinking, and then you see things in its proper light. All right, so I've already looked at analysis and interpretation of the Constitution. Let's look at the case that he was talking about. Let's see if I can go over there. Oh, before I do that, let's look at this 27 CFR 72.11. Okay, so this is 27 CFR, this Code of Federal Regulations, 72.11. So right here you see under definitions, we have the definition of commercial crimes right here. So any of the following types of crimes, federal or state, offenses against the revenue laws, which encompasses a whole lot. Burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame and like offenses, extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes, addiction to narcotic drugs, and use of marijuana will be treated as if such were commercial crime. I don't understand what they mean treated as if such were a commercial crime. I don't know what that is. That leaves some room for an expansive interpretation of something. But as you can see, use of narcotic drugs is a commercial crime. Okay? There's no injured party. They tell you that. There's no injured party with selling drugs. Nobody's been injured. It's a victim, or victim, shall I say, is considered a victimless crime. There's no victim. All right, but it's a commercial crime because it falls under the purview of the legislative authority of Congress as given to them by Article 1, Section 8, Clause 3. So when the Supreme Court justices review this, that is what they're looking at. They're looking at, does this involve interstate commerce, or does it materially affect interstate commerce? It has to fulfill both of those prongs, those prong tests. Okay, so remember what I'm saying. And I'm kind of rushing through it a little bit because there is a lot of investigating, to get to a thorough understanding of that. But I think I'm touching on all the points that you need in your study groups. You can start to investigate the things that I'm saying and find out for yourself. Okay, let's get some more likes up. And let's get some donations going. Damn, I'm sitting there rolling. Those are some donations. All right, but let's get the likes up. Let's get the likes up. Can I get about 250 likes? There's 310 people on here, 194 likes. Let's get some more likes. It will help the analytics of the channel. You already know they shadow banning my channel. All right, they shadow banning the channel. It's still, in spite of that, it's still growing. It shows you how strong the information is. In spite of their attempts to shadow ban me, it is still growing. All right. However, so y'all help this channel grow. Send out links, click share under the video, post it on your Facebook, post it on your Twitter, post it on your Instagram, post it on whatever social media account, and then also in your Facebook groups. Make sure you post a link to this in those groups as well, any of the groups that are dealing with this particular subject. All right, share this information. That helps a lot. All right, so right there we just got 27 Code of Federal Regulations 72.11. Um, this right here is the code section that's going to be discussed, 18 USC 922 unlawful acts. And let's read it real quick. It says, for any person, we already know what a person is, what a persona is. It's an artificial entity. It's an ens legis. It's a creature of the state. Except a licensed importer, licensed manufacturer, or licensed dealer to engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate foreign commerce, or B, except a licensed importer or licensed manufacturer to engage in the business of importing or manufacturing ammunition, or in the course of such business to ship, transport, or receive any ammunition in interstate or foreign commerce. And this is how all of their statutes, 90% of their statutes read like this. People just skip over it. I remember I was watching a video. I was watching an attorney talk about something. He was talking about someone commercially. He put a big ass thing on the screen, and right there it said it was commercial. I said, man, they think American people are stupid, and most of them are stupid too. They don't see it. It's commerce. It's all commercial. It's all, everything in the United States is about business. Why wouldn't common sense tell you that? That's all you do. You either work for somebody who has a business or you have a business. That's all that exists in this country, are businesses. That's it. That's it. If we didn't have businesses, we would be doing barter. And what would we need with the government, to be involved in our business? There wouldn't be no taxes, wouldn't be anything like that. It's commerce. And interstate commerce has usurped intrastate commerce because they have an expansive reading of the Commerce Clause, and so many activities that go on with the state inside the state can materially affect interstate commerce, so the federal government seizes jurisdiction over that conduct. It's wide. They have a wide range that they operate off of. You're an attorney. I'm sure you understand that, and you know that. If you're worth any of your weight as an attorney, you're 40 years, I'm sure you can read this the same way I've read it, and you understand what these people are talking about. All right, so let's get deeper into it. Let's dive deeper. Let's dive deeper. Okay, here's the case. It's one of the cases that he sent me. He sent me United States versus Lopez, volume 514, U.S. Reporter, page 549. D.C. versus Heller, volume 554, U.S. Report, page 570. McDonald versus City of Chicago, volume 561, U.S. Reporter, page 742. Burwell versus Hobby, Lobby Stores Incorporated, volume 573, U.S. Report, page 682. New York State Rifle and Pistol Association. Notice how these all corporations? Y'all seen how these all companies that we're talking about? Are you paying attention to that? These are all corporations, man. These are all these companies that we're talking about. So let's look at the case, because he said he argued. I don't know if he argued this case, but he said he won this case. Once again, it says, let me go back to recap. And I haven't even really read this case or any of these cases. He just told me this today. Within the last 2 hours, I read his comment. I put this all together within 2 hours. I haven't even read the cases. So I could be wrong, but let's see. Let's see if we are. All right. Right here, once again, it says, high frequency radio. It appears you don't grasp what constitutes arguing cases, typical layman mistakes, my work at the Supreme Court. And so he puts that out there. And then he says, he said, it is clear this gentleman does not comprehend the concept of federalism under which the U.S. operates. All right. Well, I understand what separation of powers is. That's what I need to understand in order to get a proper understanding of federalism. Okay, I need to understand what gives the government its jurisdiction, in particular, what gives each of the branches of government cognizance over a particular matter. I got to understand that all as well. That narrows it down, okay? Article I courts are limited to D.C. and federal enclaves. They are limited to the territory. So are you telling me, make sure I got an understanding of this, So you're saying an Article 1 court doesn't have cognizance over anything that has to do with the Social Security number? If people are using their Social Security number and Congress is the one that created that, it's their number on the back of the card that tells you return this card if we ask you for it? Is that what you're saying? If you're saying they don't have any authority over U.S. citizens, and that's why we have to establish whether or not what is a U.S. citizenship. It is a federal citizenship. We're talking about federalism. So you're saying that they don't exercise jurisdiction over U.S. citizens? Is that what you're saying? That's all I want to know. Come on now. Give me, go over there and make a video. I'm sure you're going to make a video, but do an intelligent video. Do an intelligent video. Do an intelligent video and do the research and put it on the screen and explain this to the people. You are concerned about the people. I am misleading the people. Okay, so if I'm misleading the people, then do what I'm doing right here. Do what I'm doing right here. And explain it to the people. Because if you were explaining it to the people and doing what you were supposed to do, I wouldn't even exist. That's how you destroy a person like me. Educate the people. That is good. All right. Let's get back. I want to digress too much. So let's get back to his the case. All right, United States versus Lopez. This is the first one. This was in 1995. This is 28 years ago. All right, so certiorari to the United States Court of Appeals for the Fifth Circuit. Okay. Argued November 8th, 1994, decided April 26, 1995. After responded, then a 12th grade student, that's Lopez, I would assume. Notice his name is written in all capital letters. We understand that doesn't mean anything. Of course, it doesn't mean anything. After responded, then a 12th grade student carried a concealed handgun into his high school. He was charged with violating the Gun-Free School Zone Act of 1990. What are we talking about? We're talking about an act. What is an act? Since we are in class, let me stop and pause and see if we can get a thorough understanding of what an act is. Let's go to our website. We can go to the dashboard. And right here under SBC University, we have our legal dictionaries. When you are a member of SBC University, you have access to all of this resource material. You see I have Blacks, Barons, Ballantines, Bouviers, Burwell, Funk and Wagnalls. These are all legal dictionaries, military law, everything on there. You have a resource, just like in a regular school. You have a library you can go to. And right here we go to Black's Law. And I'm just going to go to the 8th edition. And we're going to look up the word act. Control F, search. It appears 850 times. Now, look how we're at. Can I make this go faster? Let's see. There we go. Act of hostility. Act. All right. Okay, so we have different senses of the word. Let's see, the noun, something done or performed, especially voluntarily, any deed. That's not what we're looking for. The process of doing or performing an occurrence. Okay, we're not looking for that. Like acts and pays. Word act, where is it at? I have the third. I'm looking for the Legal act, judicial act, legal act. Okay, here it is right here, the third sense of the word. The formal product of a legislature or other deliberative body, especially a statute. For the various type of act, see sub-entries under statute. Okay, see right here, especially a statute. Okay, it is the formal product of a legislature or other deliberative body. Okay, so now we're talking about an act, like a statute. Okay, now, they can only write statutes according to the powers that have been delegated to them under Article 1, Section 8. That enumerates the powers that we, the people, delegated to our public servants under the Constitution for the United States of America. All right, so the cognizance of what they have the ability to adjudicate encompasses everything under Article 1, Section 8. That's the power that they have. All right, so you have to be brought within that cognizance, which is commercial in nature. And that is what we've been saying, that all this is commercial. That's why you see the license plate saying, I'm not involved in commerce and all of these different things. And you keep on pulling people over, beating them in the head with a nightstick, telling them that they're crazy, they don't know how to read, they're illiterate. These people don't know what they're talking about. But everything that I see that you do, every news report, every documentary, everything that you do, you don't give a thorough explanation of anything. You spend the majority of your time trying to humiliate the individuals and spend absolutely no time educating the public properly. That's almost 100% of the things that I see you put out related to this information. I'm looking at your channel. That's all it is. It's the same, just repetitive. I don't see any intelligence. I see a cookie cutter website that I see all of you doing the same thing. So we know what an act is now. So let's get back. Let's see if I can blow this up some. Okay. After respondent, then a 12th grade student, carried a concealed handgun into his high school, he was charged. We need to look up what a charge is. A charge, okay, the various senses of that word, we can see that a charge is putting a lien on property with violating, because we're talking about everything commercial. It's commercial. So the commercial sense of the word charged is what? I want you to start thinking about that. With violating the Gun-Free School Zone Act of 1990, which forbids any individual. We have to get to a thorough understanding of what the definition of individual. Again, that word is going to be intentionally obscure. When you look it up in a Black's Law Dictionary, it's going to say it's an entity, and an entity is an organization. Any individual knowingly to possess a firearm at a place that he knows, and they put he in brackets, he knows is a school zone, as you have to qualify he. Okay, 18 United States Code, subsection 922Q1A. All right, so I have that pulled up. This is it right here. And that's what I just got through reading. We talking about licensed importer, licensed manufacturer, licensed dealer to engage in the business of importing, manufacturing, or dealing in firearms, or in the course of such business to ship, transport, or receive any firearm in interstate or foreign commerce, or blah, blah, blah. All of it reads the same way. So we're talking about something commercial again in nature, is my point, as I just want to get to that. All right, so let's go back. The district court, I want y'all to do some research on the district court of the United States, a U.S. district court, and the district court of the United States, and see if there is a difference between the two. A U.S. district court and a district court of the United States. I want you to do research on the U.S. Supreme Court and the Supreme Court for the United States of America. I want you to look and see, is that worded? See if you can find the wording, how they word it differently throughout the law books. Okay, everything that falls within this territorial jurisdiction of the legislature of Congress, they started out with U.S. Postal Service, U.S. citizen, U.S. district court, U.S. person. All of it is the same. You're not U.S. code. They listed how it is, but you got to understand the distinction. You got to know that a distinction exists, because they've done as I've been doing this for 20 years, and I can tell you that on the internet, they are going to great pains to take everything off the internet that you could look up that would let you know that there is a distinction. You used to could find a lot of stuff to show you, but right now on the internet, they're scraping the internet of a lot of information, while at the same time calling you stupid and crazy, but limiting your ability to go and do accurate research. I'm almost to the point where I'm about to tell you don't even use Google anymore. Use a different search engine. Because Google really only has about 5% of what's on the internet anyway. I hope y'all know that. Hope y'all know that. You only find about 5% of what's on the internet using Google. 5, 10%, something like that. I forgot what the exact number is. All right. All right, so right here, the district court denied his motion to dismiss the indictment, concluding that 922Q is a constitutional exercise of Congress's power to regulate activities in and affecting commerce. And reversing, the Court of Appeals held that in light of what it characterized as insufficient congressional findings and legislative history, subsection 922Q is invalid as beyond Congress's power under the Commerce Clause. All right, so here's what it was held. The act exceeds Congress's Commerce Clause authority. First, although this court has upheld a wide variety of congressional acts regulating interstate economic activity that substantially affected interstate commerce. Notice we're talking about intrastate commerce that substantially affected interstate commerce that allowed Congress to exercise regulatory authority over that activity. Even though it was involving interstate commerce. What is key is they saying it materially affects, it don't have to be just interstate commerce. It can be something touching on or affecting interstate commerce. If it's involving in any kind of way that it can affect interstate commerce, they are taking jurisdiction over it. Understand that. Understand that. That's what all this is really saying. It's kind of like that movie Dune. If you ever watched that, it says the spice must flow. Commerce must flow. Money and commerce never stops. You see these trucks never stop moving. Money never stops flowing. It has to continuously flow. If you disrupt the flow of commerce, they're going to give you a charge. It's like electrocuted, and you have to discharge it. You have to discharge it. You can't affect anything with the flow of money. Money follows the same principle as electricity. That's why they use electrical terms to describe it. And you find the explanation of that in Silent Weapons for Quiet Wars. If you read that whole entire document, they give an explanation of how the entire commercial activity is following a schematic of what electricians use. Really, really interesting once you understand the design of all of this. And the circuits which control the flow of commerce are whether you're an individual, an association, a partnership, a company, a corporation, an estate, a trust. Those are the 7 entities that are used to tax the flow of commerce, or how commerce flows in the public in their system. So it's all commercial in nature. Now, they're going to great lengths, and I'm sure they're going to try to do something to make me look foolish once again, to make you appear. They don't give you no explanation of why all the words. Ask them to give you an explanation. Why y'all capitalize? Let's do something simple. Start with that. Why you capitalize everybody's name on the caption of all the pleadings of all these court cases? Why is your name capitalized on your driver's license? Why is your name capitalized on all of your utility bills? Why are all of the congressional representatives, when I see them on television and they have their nameplates in front of them, their name is in capital letters along with the judge? Why is that? I could keep going on and on and on. Start there. Give me a simple explanation and show me the authority for doing that under the rules of grammar. English grammar. Because obviously, if you're an attorney, they really select to go to law school, English grammar majors, English and also political science majors. I think those are the 2 right there. So tell me where they got that from. I've been looking. I'm not saying I know everything. I just want to know. I want you to tell me. I'll be watching for it. Okay? So let's keep reading this, all right? Let's keep reading this. held. The act exceeds Congress's Commerce Clause authority. First, although this court has upheld a wide variety of congressional acts regulating intrastate economic activity that substantially affected interstate commerce, they've already upheld a lot of acts where intrastate, meaning they didn't go outside the state, but somehow in some kind of way it affected or touched upon interstate commerce, and the courts have upheld their regulatory authority over that activity. Did I interpret that correctly? Can you give me a check and say, yeah, yes, he understood that portion? I would appreciate that. Don't be a dick all your life. You know what I'm saying? I'm objective. You be objective as well. The possession of a gun in a local school zone is in no sense an economic activity that might, through repetition elsewhere, have such a substantial effect on interstate commerce. Makes sense to me. So you say, okay, so just the possession of a gun doesn't materially affect interstate commerce, just the mere possession of it. Just the mere possession. We're talking about the possession of it. It doesn't affect interstate commerce. Interesting? Okay. Section 922Q is a criminal statute that by its terms has nothing to do with commerce or any sort of economic enterprise. No, we're talking about an enterprise. When they use that word a lot, if you've been convicted of drugs, I want you to get your indictment and read it and see how many times that word is used in there, especially if you have a conspiracy charge. Look at just read your indictment and look at all the commercial terminology that's being used in there. We may look at an indictment after this, all right? However broadly those terms are defined, nor is it an essential part of larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. It cannot therefore be sustained under the court's cases holding regulations of activities that arise out of or are connected with commercial transaction, which viewed in the aggregate substantially affects interstate commerce. Okay, where is the commercial activity, first of all, that you're engaged in by just the possession of a gun? I think that the Supreme Court justices did this wisely because it would open Pandora's box and give people a beeline into understanding how they're obtaining jurisdiction just by having a gun. These guns are produced at corporations and they have serial numbers on them. Same thing with the cars. This is the elephant in the room that people in the patriot community are refusing to discuss. How they are getting regulatory activity over these matters. And you keep telling them, well, you don't have jurisdiction over me. It gives you some insight of the length that you have to go to if you truly want to be private and independent of any governmental oversight. It takes a lot to accomplish that. That's why they have the secure party process where you still can participate in the world but not be of it. And that's what you got to understand. Because you've been conditioned and acclimated to this way of life too much, it would be too much of a shock for you to materially change. You're not going to go out and live in the woods with the bears or anything like that. And then fight to get a allodial title where you have to get rid of your 911, your mail delivery, your water, your lights, your gas, and all of that, and then provide those things for yourself. It can be done, and no way am I saying it cannot be done. But how many people are going to do that? So let's keep going. To uphold the government's contention that I'm going to read right here. To uphold the government's contention that subsection 922Q is justified because firearm possession in a local school zone does indeed substantially affect interstate commerce. So the argument that the government is making is just possession. I want you to see how these people think. I want you to see how these people think. Just possession of a firearm in some kind of way substantially affects interstate commerce, which would require this court to pile inference upon inference in a matter that would bid fair to convert Congressional Commerce Clause. The court would have to take all these inferences from act, and I understand how they rule like this, but I want you to see when he give me cases like this, how I expose some things, all right? Because see, I read criminal cases all the time, and this is the same thing I'm talking about.
How does the government get jurisdiction? That's the first thing I'm looking at any criminal case. The activity that you engage in, that you got an indictment on, how did the government get jurisdiction, and where is the jurisdictional element announced in the indictment? It should be there. Where are we at? Let's see where we at. Wait till you see my response. I'm going to be waiting for it. We're going to go back and forth. We're going to go back and forth. I'm going to be waiting for your response because you don't come on my page and tell me something. I've been doing this a long time too. I've been doing this for a very long time, and I'll match my intelligence with yours any day. And as a matter of fact, if you like to have a public debate about this, we can get down. I'll make you famous. You only got 6,000 followers. You ain't making shit. You ain't getting monetized over there, so why are you putting so much energy into it? So anytime you want to get down, bruh, we can get down with it. Because right now, I'm only giving you just a little bit. I'm doing a cursory overview of all of this. But you don't scare me. None of y'all do. Because you know why? Because I got the truth. And I see how y'all get down. See, we're talking about the truth. And the truth ain't in you. That's what the Bible warned us about attorneys, that y'all are liars in a den of vipers. And that's the stigma that is associated with your profession. So you're at a disadvantage already off the rip until you can change that narrative about your profession, that you're a den of snakes and vipers and liars. And I can go pull criminal case after criminal case and see where y'all done filed the same paperwork on everybody's case. And all you do is plea bargain 95. That's why you have a 98.5% conviction rate on state and federal levels. You don't do shit for your clients, but you take their money. Won't you go do a response on that? And make sure you use this clip. Put my channel up. I see you got other people's channels on there. All right. I'm following the 48 laws of power. I'm intentionally trying to make an enemy. I'm calling you out to war. I'm calling you to war. You think I went through all this years ago and I'm gonna bow down to some bitch ass nigga like you? You crazy as hell. I'm calling you a bitch ass because I'm hoping to put some fire up under your ass. Wipe all that shit off your channel and just put my shit on there and let's go. You ain't getting no views any fucking way. Talking about what he's seen so far is easy to debunk. Bullshit. Make sure you start with principles. Make sure you start with these right here. Because you like to talk about federal, and we're talking about the Supreme Court, right? So make sure that you start with the principles, all right? Republicanism, explain that to your listening audience. Separation of powers, explain that to your listening audience. Limited government, the limitation of governmental powers, explain that to your listening audience. Popular sovereignty, explain that. You know, Chisholm versus Georgia in the 11th Amendment where they say it's been changed, that sovereignty is deposited collectively under the federal government. You know, I know that's what you believe. It's some bullshit. And you got attorneys out there, Jewish attorneys, that are debunking that. Not me. Your people within your circle. Federalism, checks and balances, and individual rights. Anytime the Supreme Court makes a decision on anything that it is issued certiorari on, these are the principles they're making their decisions by. You do know that as an attorney. I'm sure you're a constitutional attorney. If you have to have taken some constitutional classes in law school if you're arguing constitutional matters before the Supreme Court. So I know you know this right here. Make sure that you educate, you start with the principles. And then from those principles, you begin to give your explanation. Can I get an agreement on that? Can I get an agreement on that? Can I get an agreement on that? I just want to I'm waiting for his response. I'm gonna wait on your response. Let's keep going. Let's finish looking at this. Let's finish looking at this. As you can see, everything we're reading, I don't see how they're going to, everything we're reading is talking about something commercial. Everything we reading is talking about something commercial. It's on everything that I read. I don't do anything but read y'all stuff. You think I sit over here and read sovereign citizen information? The ones that I tell my listeners to read is something that I have vetted, that they are walking the same path that I'm on. I'm not the only researcher that's seeing this, by no means. And for you to be here tells me I must be doing something right. Because if I wasn't talking about shit, you wouldn't ignore me. Just like I ignore your fucking page. I didn't even know it was in existence. Because the shit you talking about don't have no interest to me whatsoever. But some kind of way, I must be materially affecting what is going on in your life for you to spend so much time and energy addressing the subject matter that I'm discussing, and also hide your identity while you're doing it. Because you already know the first thing I'm going to look for when you reveal your identity is your nationality. You know what it is. So let's keep going. Let's finish looking at this case. He want me to read it. Let's reading it. Hold on, before I go any further, I'm gonna go further, but I want to show y'all something real quick. Let me see, this is it right here. All right. This right here is an indictment by Tekashi 6ix9ine. I don't know if y'all remember that rapper. If y'all get on the internet. And Tekashi 6ix9ine, if you watching this is educational for you, bruh. This is him right here. I don't know if you're familiar with him. I kind of follow hip hop a little bit. You know, he got caught up. He was doing videos too blatantly talking about selling drugs, and the organization he was a part of, allegedly they were involved in violent activity and things like that. And he eventually got indicted for the things that he was rapping about in his songs, and which led to an indictment. And the first thing that happened, when it happened, I told everybody that he was going to, was going to tell on people, because that's the kind of pressure they put on you. And I'm not in any kind of way trying to down the brother's character for doing so. It's only people who aren't involved in the criminal justice system that make fun of people and say, oh, you're a snitch. And, you know, I ask you, if you were presented with a situation where somebody was about to give you 39 years in prison, but if you told on two people, we'll give you probation or 2 years, what would you take? And let's say that you had a wife and children, and you're talking about 39 years away from your family. I'm just trying to get you to, I'm not trying to condone snitching or anything like that, but I'm trying to make you understand why you should not be involved in activity where you would have to make that decision in the first place. Stay away from that kind of activity. You don't want to be put in that situation. My life was destroyed behind a circumstance like that where I elected to keep it real and not tell on anybody, and they punished me for it. I don't have no rule 30, 35 in any of my pre-sentence investigation reports or anything like that. You can't find it nowhere on me. There's not a whiff of it anywhere. However, you're going to pay a price for that. And sometimes it may cost you your family. So you need to weigh that, your integrity as a man as it relates to your relation to your peers in the street, how you want them to perceive you, or whether or not you have family values. I was a young man at the time, not possessed of the wisdom that I have right now. Because if I had the wisdom that I have right now, I would not have even been engaged in conduct that I was engaged in back then. I would have taken a different course of action. But I wanted you to see who he is. Now, this is his indictment. He got indicted. And notice at the first line, we say the enterprise. It's called the enterprise. At all times relevant to this indictment, and once again, they write the names in all capital letters. But of course, that don't mean nothing. That don't mean nothing, y'all. That does not mean anything. Once again, in your explanation, I want you to cite the authority for writing names in all capital letters and the reason and rationale for doing so. I want you to accurately, don't give us some old bullshit answer. I want you to go thorough into it and explain why you capitalize all these names like this. This is something we want to know. This is something the patriot community has been saying for the last 30 years and they can't get an answer. So why don't you do us a favor and answer it for us? Okay? So it keeps on, and Fahim Walter, a.k.a. Crippy, the defendants, and others known and unknown, were members and associates. We got members, associates of the non-trade gangster bloods, non-trade or the enterprise. Non-trade is being synonymous of some sort of business enterprise. A criminal organization, that's what an individual is, an organization, remember, whose members and associates are engaged, among other activities, acts involving murder, robbery, and narcotics trafficking, a commercial term, trafficking. Non-trade operated, commercial term, in and around Manhattan, a commercial district, the Bronx and Brooklyn, New York. They're not saying that for any reason. They're telling you these people were conducting unlicensed business within this jurisdiction of Manhattan, Bronx, and Brooklyn, New York. Non-trade, including its leadership, okay, we have a leadership in an organization, its membership, and its associates constituted an enterprise as defined by Title 18 United States Code, Section 1961-4. All this is jurisdictional information right at the beginning of the indictment. That is a group, commercial term, of individuals, look up the word commercial term, associated, commercial term, in fact, although not a legal entity, have been formally incorporated with the Secretary of State. The enterprise constituted an ongoing organization whose members function as a continuing unit for a common purpose of achieving the objectives of the enterprise. And at all times relevant to this indictment, the enterprise was engaged in and its activities affected interstate and foreign commerce. Now, when we go back and read the Supreme Court analysis and interpretation, you just see when they see criminal activities, this is your explanation right here. This is an example right here of what was being discussed in the introduction of Supreme Court analysis and interpretation of the Constitution. And the introduction at the second portion where it talks about the Commerce Clause and the expansive reading of that clause. Can we agree that this is all considered commercial activity? Will you do me that? And if it's not considered commercial activity, what does it fall under? And what jurisdiction, I want you to do this. I want you to give a thorough explanation of this in your response. What jurisdiction are the courts operating under? Pursuant to the Constitution of the United States of America. Don't give me no bullshit like a statutory jurisdiction. I want to know, is this common law? Is this equity? Or is it admiralty maritime? Those are the jurisdictions that are discussed in the Constitution. What are we talking about, Article 1 courts or Article 3 courts? When you argued your case in the lower court, was it an Article 1 court or an Article 3 court? And substantiate your position for that conclusion in your response. Let's keep going. At all times relevant to this indictment, the enterprise, okay, what is it going? Where am I at? Okay, we stop right here. Interstate commerce. Jamel Jones and mail murder. Cafano Jordan, they got their real name. Notice that they have their public name in all caps and a nickname, or what is called your private name, in your Christian appellation of your name. Like Yusavale is my private name. That's not my state issued name. So they have, so notice that they have the their state name or their government name is in all caps, also known as, and then they put their private name in the Christian appellation of their name. Because you can call yourself whatever you want privately because it's not registered with the state. You don't have to go by whatever your government name is in the private amongst your friends. Your friends can refer to you whatever you want to because that's private. You can call yourself whatever you want in the private. What they are concerned with is what you have registered at in the government database as your name to conduct business with. Just like you have to change the name of a corporation and the legal procedure you have to go through, you got to go through that same procedure to change your legal name. But what happens? The EIN number doesn't change with the corporation, and guess what? You change your name, the social security number doesn't change with it, because that is not the minimum contact that they are concerned with. The straw man is a number, not a name. You a number in prison and you a number on the street. Where we at? Where we at? Where we at? Where we at? I'm going back to Lopez in a minute, but I wanted to give you an example of how this is another. I want you to, when you read these cases now, I'm not going to read this anymore. I wanted you to see what to start at, so you could look with a different set of eyes when you're reading an indictment. I'm giving you the keys of how to read this stuff. All right, so let's go back. And I would like to see the original indictment for this. Let me see if I can find the original indictment. Let me see if I can find the original indictment of this case. Of this case that he gave me, of this Lopez case. And where I would just put it. I was 27. Did I close it? Oh, there it is right there. United States versus Lopez. So let me see if I can find. Let me see if I can find the indictment. I need to see if I can see the indictment of it. There's the actual syllabus. That's the actual case right there in the books right there. That's interesting. Notice they talking about the Commerce Clause all through here. I'm going to say that later. Let's see, United States versus Lopez. See, I wanted to find, do you have the original indictment? Send me the original indictment. Since you want it, I'd like to read the original indictment. This is a petition for rehearing. That's not it. I don't know what that is.
Is this something else? I think this is something else. This like the is this the stenographic record of the proceedings right here? This look like, is this the it's like this stenographic record of it. Yes, court. This is a court reporter. The Court of Appeals held that the statute unconstitutional because neither the statute nor its legislative history contained express congressional findings identifying the nexus. Let's read this real quick. Nexus means connection. Let me read it from the beginning. Good day. Thank you, Mr. Chief Justice, and it may please the court. In this case, the Court of Appeals has taken the extraordinary step of invalidating an act of Congress as beyond its power, ultra vires, under the Commerce Clause. The act in question, known as the Gun-Free School Zones Act of 1990, makes it unlawful for any individual knowingly to possess a firearm within a distance of 1,000 feet from the grounds of an elementary or secondary school. The Court of Appeals held the statute unconstitutional because neither the statute nor its legislative history contained express congressional findings identifying the nexus between interstate commerce and gun possession in schoolyards. The Court of Appeals reached its erroneous result, in our estimation, through a fundamental misreading and misapplication of the precedents of this court. First, the court imposed on Congress a requirement that it make make legislative findings as to the nexus between the activity it was regulating here and interstate commerce to satisfy the court that it was exercising that power in a constitutional manner. Of course. What's wrong with that? I mean, yeah, there has to be some sort of nexus to what the power that's been delegated to you. In doing so, the Court of Appeals essentially treated Congress as though it was subject to procedural rules that would be appropriate in the context of a judicial or administrative proceeding, but not where Congress was legislating for the entire nation pursuant to its plenary powers under the Constitution. Remember I said plenary powers when it's exercising under Article 1, Section 8, Clause 17? That is the word that you have to understand. The plenary powers of Congress is anything within Article 1's cognizance. Anything that's been delegated to them under Article 1, Section 8, and those enumerated powers, they're exercising plenary power. So when you come into that territory, you are subject to them. They are not subject to you. And that's why we have to question what is a U.S. citizen. We have to question that. It didn't exist prior to the 14th Amendment. So at least, you know, people who were here prior to you coming, AKA the Moors, as well as every white person that was already here, should be able to question how they are labeled a U.S. citizen. They have a state citizenship. There's a distinction between a U.S. citizen and a state citizenship. There's a plethora of case law supporting that and substantiating it. In doing so, the Court of Appeals essentially treated Congress as though it was subject to procedural rules that would be appropriate in the context of a judicial or administrative proceeding, but not where Congress was legislating for the entire nation pursuant to its plenary powers under the Constitution. That is what I guess he's alluding to, that they were exercising their power under those plenary power provisions under the Constitution. That is a doctrine. And it is a result of separation of powers. This is, again, why I say you have to understand separation of powers. You can't understand plenary powers doctrine if you don't understand separation of powers doctrine. Question. Well, if it were concerned that the original understandings and structural theories that underlie the federal system have been so eroded that the whole system is in danger. What? Well, if we are concerned that the original understandings and structural theories that underlie the federal system have been so eroded that the whole system is in danger, I didn't take that from that. I didn't take that the system had been eroded in any kind of way. I take it that it would be appropriate for us to consider some procedural guarantees, okay? Yes, and this court has considered and imposed certain procedural guarantees where, for example, it felt that Congress was legislating in a way that encroached upon the operations of state governments. As in the case of New York versus United States, where this court held that Congress could not legislate to the extent it did to require that state take title to certain nuclear waste. Once again, we're talking about something business, commercial. It's done so under what has been referred to in the Court of Appeals decision as the clear statement rule or the plain statement rule, that where there are incursions upon government operations, notice coming into the public,
incursions upon government operations, that Congress has to make its intent to exercise its authority to the fullest extent clear in the legislation, and there cannot be any ambiguity in that respect. I agree, even though I think statutes are construed in favor of Congress. Am I right? You know, but I get what they're saying with that. You know, it's like, hey, the conundrum is we got to write our statutory codes and make it clear what we are exercising authority over. If we don't, then you're going to construe it, well, you didn't put it in there, you didn't say it clear. So I understand that. It says, but what this court has been doing is looking at, as it properly should, limitations on the exercise of the Commerce Clause found within the Constitution itself, and not based upon some generalized concern that Congress was going too far in carrying out that responsibility. Also, isn't there I read a case where it said that when a government official has chosen to exercise some sort of constitutionally delegated authority upon you in some kind of way, okay, that's a presumption that they have that authority unless you test the limits of that authority. That is why you always ask them what their delegation of authority is. You have to, the only way we can determine as a people something is unconstitutional is by challenging it. Because Congress, we know that once you watch that video that I showed you earlier about Judge Scalia and Judge Breyer in the Judiciary Committee and the role of the Supreme Court under the Constitution, they talk about what we can get away with. They will try to write some legislation that is unconstitutional, and it will remain so unless somebody challenges it. That's what the Supreme Court is for. But what this court has been doing is looking at, as it properly should, limitations on the exercise of the Commerce Clause found within the Constitution itself, and not based upon some generalized concern that Congress was going too far in carrying out that responsibility. Question, well, let's do exactly that and ask whether the simple possession of something at or near a school is commerce at all. So is that the question? That's the same thing we've been saying. Are we engaged in commercial activity? General Days, I think the answer to that is that it is yes, Your Honor. So I guess this is the government, it has to be, arguing that just the mere possession of having a gun on school grounds in some way materially affects interstate commerce. Now, that is a question we have to explore. They have to explain that to us. How me driving my car materially affects commerce in some kind of way. That's what the people want to know. They want you to explain that to them. So in that explanation, they can, under being fully informed, okay, check their conduct, decide, make an accurate decision of what conduct that they want to engage in. With the full, that's what the people in the patriot community are arguing. You're doing everything without giving full disclosure of all the material facts. That's what people are talking about. That's why they come to shows like this. If you would do that job, you put me out of business tomorrow. I'm feeling a void. And you don't like the explanation I'm giving. Well, give a better one. I enjoy the childish response. Okay. So it's a childish response. Okay. It'd be interesting to see yours. I'll be interested in seeing yours. I'm gonna wait for it. I'm looking for it. All right. This is his profile, everybody.
This is the guy that is commenting right now and calls himself John Galt. I guess you read Atlas Shrugged. You know, Atlas Shrugged. Atlas had the world on his back and he shrugged to get it off his back. Are you, you know, Ayn Rand, that was kind of like an anti-liberal type of treatise that she wrote under, you know, Atlas Shrugged. I read the whole thing, all 1,000 and how many ever pages of it. It was very good reading. Very good reading. Atlas Shrugged, you know, she got, Randism, Ayn Rand, Randism, or whatever it is. You know, she have a philosophy. And Mike Wallace has an interview with her on YouTube. Everybody should watch that interview with Ayn Rand. This is her right here, Ayn Rand. And Mike Wallace interview, if you want to get some insight, Ayn Rand and Mike Wallace. So you see he calls himself, what he calls himself, John Galt. John Galt
Here's
was
an
a
easy thing you can do
character in her novel, Atlas Shrugged.
add to your routine
who is John
so
Galt?
that you age better, or
So
maybe
those of y'all, this is something that you should really watch. This interview between, this is a very intelligent lady. She is Jewish, by the way. She's Jewish as well, and she is very intelligent. And I enjoy listening to her speak. I mean, she's kind of like a Candace Owens, you know, of her time, or of her time. And Candace Owens, if you're out there watching, you are incredible. I mean, you are incredible. I don't see too many women out there like you in the world at all. Not in the public, at least, not in the public eye. I don't see too many out there in the public eye like you. And to rise from such an obscure beginning and to get such renown is a testament to your intelligence and you know, the sharpness of your thinking. And you got a lot of respect. You are definitely a goddess of what a goddess should be. Definitely. You know, I'm giving you that props. But Ayn Rand also demonstrates those same characteristics, in my opinion. So, you know, definitely this is a woman. You should take the time to listen. And finally, when I got older, I decided to read it because it was a real big book. And when I was young, I didn't want to read it. I was like, damn, I want to read that big ass book. And I finally got an opportunity to read it from cover to cover. And it was, man, it was like, that was a great book. And they did a very good job with the movie, I think, too. The movie was, read the book first and then watch the movie. It definitely was good. Where am I at? I'm getting all sidetracked. Okay, so, well, you should be. She's one of your mentors. You should see the extent of my reading as well. You know, I read The Fountainhead as well, and so you know, I have respect for this woman, and I point that out that she was Jewish because I want people to understand I'm not racist. I respect a lot of Jewish individuals, a lot of them. They make excellent. I love the Beastie Boys. I still listen to Paul Revere to this day. You know, I was like, man, these white boys, they got down, the Beastie Boys. So not in any kind of way do I have anything against Jews in and of itself. I have something against a certain political ideology that is rooted in some sort of religious theocracy that I take issue with. That when you look at the roots of that religious platform, it's not based in anything solid. It's not based in anything solid. They're deriving it from other cultures, and it's being watered down. And I am referencing the entire Bible, including the Torah. So there cannot be any substance that we are the chosen people. That's a Jedi fucking mind trick. That's a Jedi fucking mind trick. Straight up, okay? Straight up. Where am I at? Okay, let me get back to this. Shalom alaikum, Ilahem. You're not allowed. You follow up philosophy and base your legal career on it, then you should be in favor of the republic then.
You should understand what we're talking about over here then. If you follow her philosophy, she wasn't against capitalism. She understood that capitalism was the platform that made America, and it is the impetus for society moving forward, for invention. And that socialism, communism, and Marxism is some bullshit that is based on some sort of satanic belief that ain't nothing but a tool for a group of people to take everybody else over, convert them into heathens, telling them they're being oppressed by those with money, when in reality, anybody can have money if they just change their thinking and start thinking, change their thinking, do an alchemical process where they convert from a poverty mentality to an abundance mentality, and their world will just magically change. You are where you're at right now based off of where you thought about 8 or 9 months ago. That's where you at. You're thinking about 8 or 9 months ago, whatever situation you're in right now is the result of that. So when you change your thinking and start thinking in now terms, your situation will change. You ain't being victimized. The only victim is you're victimizing yourself. You look insane because you're thinking something. That thought is going out into the universe and it's coming back to you, and then it's creating some sort of situation in your life. But you, instead of being accountable for your own conduct and the things that you're doing, you blame it on outside circumstances. And so the process keeps repeating itself. So by refusal for you to accept that you're a god or a goddess, that you have control over anything, that you were giving the most powerful weapon in the universe, and it's called the mind. By you refusing to acknowledge and accept that and keep associating outside circumstances as a result of some outside influence instead of attributing it to the real cause, which is an internal factor, i.e. your thoughts. As long as you won't key in on that, you're going to remain right where you're at. And as a matter of fact, they'll exercise more and more authority over you because you haven't learned to govern the mental. You ain't learned to govern the mental. Did that not change? Yeah, that's her. I really like Ayn Rand. That Mike Wallace interview, once again, I stress, I'm going to put it as a card on my video as well to remind you to watch that video and listen to the woman speak. I mean, she has some good philosophy on things like love. I mean, her position on the type of woman a man has sex with was just beautifully stated. It's beautifully stated. I have it on my Instagram page right now, as a matter of fact. When you first go to my Instagram page, I have a quote from her on that, and it is a video. It's a short video, and it's beautiful. Very intelligent woman. Can't say enough about her. I haven't found anything to criticize her about. Where am I at, man? So I want to get back to reading this. Okay, this stenographic record of the proceedings. This is very interesting to be able to find this. All right, it's very interesting to be able to find this. Okay. So I want to go back to where he says, I think the answer to that is that it is yes, Your Honor. I would have thought that it wasn't, and I would have thought that it, moreover, is not interstate. Justice O'Connor, if this is covered, what's left of enumerated powers? What is there that Congress could not do under this rubric, if you are correct? Justice O'Connor, that certainly is a question that one might ask, but this court has asked. Damn, I keep trying to,
This thing keeps flipping too fast, man. It keeps making me lose my place. Hold on. Okay, right there. Okay, general days. What is general days? Justice O'Connor, that certainly is a great question that one might ask, but this court has asked that question in a number of other circumstances. And rather than starting from the assumption that something was inherently local, it's looked at the degree to which Congress had a reasonable basis for extending its authority under the commerce power to regulate that particular activity. This is why I read case law, because they just teach you in the documents. They teach you in the documents. It really is like going to school. I understand why they read case law in law school, because it's how you learn the law. But in some of those very cases, general days, the statement is found that the power is not limitless. And that is the assumption that I've had about the Commerce Clause, that it's limitless. You know, like I said, it has a very, very broad interpretation associated with it, and I've yet to find the limit of their power. That's what we're looking for. If you have tell us what the limit is, then we can now understand how to operate outside it. But like, once again, we're not giving the full explanation of all of this. But I assume that it's limitless, the commerce power. Everything that I've read, I haven't found the limitation on it. Well, I have what I thought is the expected limitation about being private, but this minimum contact thing has made me question, okay, well, what exactly is private? I think that the key to destroying the privacy of the people in the United States of America is when y'all took away gold and silver. That was it. That was the coup de grace, taking the gold and silver, because we could no longer engage in private transactions. You know, we were doing exchange, money of exchange. The government wasn't in our business at all. Wasn't no taxes and all of that. When they centralized the money system and took away gold and silver and then issued you Federal Reserve notes that, by the way, are unconstitutional, but that can only be circulated within that territorial jurisdiction of that plenary power of Congress. That's why we have a Federal Reserve Act that falls under the purview of their Commerce Clause. So you have to have a certain status to engage in activity in the public. And that's why they make you a U.S. citizen. And they give you a club card called a Social Security card. That's your number to go into their system. I don't understand why this ain't like self-explanatory to some of you attorneys, if you have the knowledge that you claim that you do. I mean, I'm looking at it, it's easy for me to see you're going to deny it. See, I've been to court too, so I'm familiar with all the ways you evade answering the question. And that's what a lot of newbies are going to have problems with. This word obfuscation, your ability to obfuscate or to circumvent answering the question, or ducking and dodging like a slippery eel, using words of art and things like that. If they're not familiar with that technique, then yeah, they're going to have a hard time dealing with you. It takes some experience and a lot of reading to be able to look through the veil of deception. It says, well, it said, well, that is certainly the case, Chief Justice Rehnquist. That's an understanding from the Constitution, but one has to look at it where the limitations are that are imposed by the Constitution itself. Well, what would be if this case is Congress can reach under the interstate commerce power? Let me see. Well, what would be if this case is Congress can reach under the interstate commerce power? What would be an example of a case which you couldn't reach? Good question. General Days, well, Your Honor, I'm not prepared to speculate generally, obviously, but that was a good-ass question that Chief Justice hit him with. He said, give me an example of a case that you couldn't reach. Do you want to put that on the record? Do they want to put that on the record? I would wonder, did Congress want to put anything on the record of examples of something that's outside their purview? Do they want to put that on the record and tell everybody clearly, state on the record what they don't have authority over? That's pretty interesting. Well, Your Honor, Hey, wait a minute. Y'all riding with me still. I got to make sure. I just be talking. I just be talking. You said the Supreme Court of the United States expanded the Commerce Clause in Wickard versus Fieldburn. I hate that decision. Well, that's what we're talking about in this. Okay, if you want to read something, then read this document right here. Read this right here. If you want to read this document right here and do a review on this on your channel, the Special Maritime Jurisdiction Exposed. Go in and do this in all the case law where they're discussing the expansion of the Commerce Clause. It even goes into driving an automobile. All right, go in and look at this. And all criminal prosecution, we need to go and read this entire thing and look at what it's talking about. This was an excellent document and some excellent research, y'all. Excellent research. He gives his citations of authority and everything in here. And he does the same thing I do. He's looking at case law. He's looking at case law. That means you're doing research. You're doing real research when you start looking at the case law. And these citations of authority are in here. And this is some very good citations of authority. Special Maritime Jurisdiction Exposed. Excellent document. Anybody who is seriously interested in this subject should study this document. It's high on my list. Well, Your Honor, I'm not prepared to speculate generally, but this court has found that Congress, for example, in New York versus United States, could not require New York State to carry out certain responsibilities because it was commandeering the instrumentalities of the state. Because it was commandeering instrumentalities of the state? Okay, so you took possession of something that was state property and then you start trying to make them take on certain responsibilities too. I would think that would be an exercise of something outside of your authority. That would be almost like, the government, that would open the doors to a whole bunch of crazy things that the government could just take over everything. Well, the objection there was that it was objecting, I think they already have because everybody's using Federal Reserve notes. You're just trying to hide it. Well, the objection there was that it was objecting the state governmental machinery to operate in a certain way. The question here, it seems to me, is quite different. The question here is the universe of transactions that the Congress may reach. General Days, yes. Question, can you tell me, Mr. Days, has there been anything in our recent history in the last 20 years where it appears that Congress has made a considered judgment that it could not reach a particular subject? Laughter. General Days, I don't know whether there has been a conscious effort to do that, but I think, as this court has said in its 10th Amendment jurisprudence, that Congress reflects the will of the people, and it has built into it and into its operations a concern about the extent to which its regulations and its legislation would encroach on matters that have been traditionally left to the state. I like that. I don't know whether there's been a conscious effort to do that, but I think, as this court has said in its 10th Amendment jurisprudence, that Congress reflects the will of the people. It's supposed to. We're supposed to be their constituency. And it is built into it and into its operations a concern about the extent to which its regulations and its legislation would encroach on matters that have been traditionally led to the state. Okay, so there's this deprivation. The state is the people. I see what they're saying, and we didn't. Everything that's not been delegated to you has been reserved to the state and to the people. So, like it says in the Constitution. So, what matters are beyond your purview. I think this is what y'all are getting at, or beyond, outside the reach of congressional control. Question, Mr. Days, we have really not been to what should I say too strict about what the farthest reach of the Commerce Clause may be. But as I read and they haven't. But as I read our cases, the ones that are most often cited, indeed, I think all of them involve the issue of whether some commercial activity of some sort, renting a hotel room, growing a commodity that is used in commerce, whether some commercial activity is interstate commerce or not, and one can say we're prepared to be very broad-minded about it. If Congress says some commercial activity is interstate or affects interstate commerce, that's okay. That's everything they talking about. But as I read our cases, the ones that are most often cited, indeed, I think all of them involve the issue of whether some commercial activity of some sort, renting a hotel room, growing a commodity that is used in commerce, whether some commercial activity is interstate commerce or not. And one can say we're prepared to be very broad-minded about this. If Congress says some commercial activity is interstate commerce or affects interstate commerce, that's okay. Now, when you go and read analysis and interpretation of the Constitution, the Supreme Court says in there, he said the Commerce Clause has caused more litigation than any other clause in the Constitution. I'm telling y'all where to go read this. I like it when people go behind me and say, you were right, Yusuf, it was in there. I'm going to be arrogant about it because it gives you that wow factor, like, this motherfucker actually read this shit. You know, that's what it does to you, don't it? That's why you respect me, because you go back and read that shit, and then you say, this motherfucker was kicking this shit off the top of his head, and I go back and read it, and that's what it's talking about. That's what's, I know I'm going to be arrogant about it, but that's what makes you like, listen, I got to listen to this dude some more and see what he's talking about. Because I'm telling you where to look, because I want you to get in the habit of looking and researching for yourself, because that's the only way another me is going to pop up. I'm looking for another me. I'm trying to okay, there's somebody out there who's as good or better than me, and you're going to get the baton. You're going to get the baton. It's somebody out there like that. It's somebody out there motivated. It's somebody out there that feels this is their calling and their purpose. It's somebody that's going to take the torch and keep it going. And that somebody's going to stand out above all the rest. And it's going to be one person. That's just my prediction. That's my prediction. Let me keep going. Let me stop and look. He said the document cites a bunch of cases from the 1800s that probably aren't still good law. Well, then go shepherdize them and come back and tell us that it's not still good law. Just you sitting there on here talking about it's probably not still good law. If it's not good law, then go ahead and go ahead and shepherdize it and see. I know what good law is. She's saying good law, y'all. What good law is, good law. Good law is a concept in jurisprudence that legal decision is still valid or holds legal weight. A good law decision has not been overturned during an appeal or otherwise rendered obsolete, such as by a change in the underlying law. Okay, now that's what she's saying. It hasn't been overruled. And that's why you shepherdize cases to make sure it's still good law. All right, that's what she's saying. And if you're presuming that, then you go do it and come back and tell us whether or not it's still good law. And I hope you have that same energy when you find out it is still good law, and you can come back and tell everybody that the cases in there are good law or not if it's bad law. Why don't you go do that since you broached that? You broach and you're the one proposing the question of whether or not it's still good law. So go do the research on it. I'm gonna tell you it ain't been overturned. I believe you read it, you just don't understand it. No, I think you don't understand it. I think your intelligence is inferior to mine. I don't think you have a good understanding of it. You over here on my channel listening to me for a reason.
So obvious I'm superior to you in some kind of way because you came to me. But you don't think I have a thorough understanding of it, so I am going to take the position that you are the one lacking the necessary cognitive skills to be perceptible enough to understand the nuances of the information that I'm discussing. And I really believe that. I'm arrogant like that. He said, I know super sidestep. However, when filing the UCC1, I'm a tad confused on when claiming the family. Is that established all in the security agreement or still use the UCC1? There has to be a security agreement for you to be able to file a UCC1. And yes, it is in the security agreement. The UCC1 under the section 4, which is the collateral description, because you're filing a UCC1 because you're filing a lien against property. Okay, the reason you're filing a lien against property, because as I'm showing you right now, all things are commercial in their system. And in order to create value in their system, and a system that is bankrupt, and in a system that uses debt currency, okay, they have to file liens against property. They have to have an interest in property that's represented by a lien. Anytime there's a lien, there's evidence of a debt. Anytime there's evidence of a debt, that means there's a creditor and a debtor relationship. You have to be the creditor because they took the gold away from the American people, now are expecting people to pay for things, when the Constitution clearly contemplates that the only way you could pay a debt is with gold or silver, but gold or silver has been removed. Hence, we have the Federal Reserve and a Federal Reserve District, people given card memberships to act with inside of that district, because in the constitutional republic, you can only use gold and silver. So they found a loophole to sidestep that under their plenary powers doctrine by making everybody into a U.S. citizen and making them a federal citizen and creating and bringing them under their territorial jurisdiction that they exercise plenary power under. That's my position. If you're going to argue with me, that's my position. I've looked at it, and I can, reading the Constitution, and one of the things that you don't acknowledge in your explanation is the impact of the bankruptcy and what happened in 1933. And explain how the courts changed under the Erie versus Tompkins Railroad decision. Okay, there isn't any money. To have a nation, you have to have land, a people, and money. And the only thing that is money is gold and silver. Anything else is credit. Anything else is an IOU. So, operating under that premise, from, I guess, a reading of the Constitution, which everybody, which all American citizens should be able to understand. It should be written in simple enough language that a regular citizen should be able to understand it, especially in light of the fact that ignorance of the law is no excuse, especially in light of the fact that the Constitution is what restricts government. It would make sense that the American people should be experts in that subject. Why is that not being taught from elementary school on in the public school system? Let's discuss that also. Let's discuss that. You didn't open a Pandora's box. This is a rabbit hole, as one judge told me. He didn't want to go down that rabbit hole. See, this is a rabbit hole. It goes from subject. See, once you start going down this, it's a lot of motherfucking questions you got to answer. A lot of goddamn questions you got to answer. You sure you want to go down this path? You sure you want to go down this path? I'm already reading. You already led me to the stenographic record of the proceedings. So I know who the participants are. I'm getting the names.
Okay, somebody said, I called the company that handles Florida UCC filings, and the woman told me that they don't do UCC 11s because people were doing them on themselves. I'd be interested in seeing that. And why not? Why you can't do them on yourself? Why you can't do a search on your name to see if anybody's filed a claim against you? There are people who find them. What do you mean they tell me they're doing it themselves? See, that's that all caps name that I was talking about. They won't explain to you why they capitalize everything, but then they try to call you crazy, say you're filing claims against yourself. When you're not filing it against yourself, you're filing it against the artificial person, the persona that's in the public. There's a public and a private. You're filing it against the public you, not the private you. There's a distinction between the public and the private. That's why I've been pointing this out during the course of this video, like in the Tekashi 6ix9ine example that I was talking about, how their government names were in capital letters, but their private names or their nicknames were in the Christian appellation of their name. They going by what's in there, what's associated with that social security number, which is a card you have in your possession that is also written in all capital letters, that has an account number on the back with a corresponding Federal Reserve district. That's what that letter indicates. Hey, it gets a rabbit hole. It gets to be a rabbit hole. You know, I got to read all of these different cases and everything, and, you know, and find out in every turn I go down, we're talking about something commercial. That's what this justice just said. He said almost all our cases are the ones that we cite most often are dealing with some sort of commercial matter, whether it's interstate or interstate. It's the same thing I see in everything that I read. In every statute, every case is something commercially related. That's why, you know, we're sitting here saying, what the fuck are you talking about? I'm looking at what y'all talking about. He said, I'm telling you, I've had a lot of experience of being harassed by Juan on Discord. He's saying the same crap and using the same tactics he's been using for years. He's a disruption agent. And I'm telling you, that's why I pay attention to the comments section. You know, it's this thing, your energy announces who you are before you speak. One thing that coming from radio did for me, radio allowed me to read people's energies through the phone because all I could hear is their voice. And it's amazing what other senses of the body kick in when you take away other senses. When you take away your ability to see another person, but you only hear their voice, and that's all you're doing all day is speaking to people, you start learning to gauge an individual's spirit even before they speak. And their energy will tell you everything you need to know about them. And a lot of times, that's what you see when you see me respond in certain ways. That's kind of like what I'm doing. I'm kind of like, I'm an empath in that kind of way. And I read people's energy, even getting to the point when you sometimes, if I'm not reading things too fast, because sometimes I'll read things too fast and misinterpret what someone is saying. But you can tell a person's energy by reading their comments and then asking the question, well, why are you so concerned with this information if it's something that is stupid or don't have any basis in law and fact or anything like that? You know, I don't understand why the attorneys aren't spending more time to explaining to people why innocent people have to plead guilty, why you have a 98.6% conviction rate and so many people in the criminal justice system are coming out haven't been convicted of anything, and how all of you tend to all file the same paperwork on a criminal case or don't do anything at all. You just take people's money, give them the impression that you're going to fight their case, and you come back with a plea agreement. And then if they don't accept it, you remove yourself from the case. This is not me saying this. This is from me talking to hundreds and hundreds of people all the time, and them all telling me the same story over and over and over again. It's the same story. You know, I look for an explanation of that. You know, I want to know what that's all about.
why nobody is getting adequate, like it says, the number one thing everybody in prison is trying to use to get back in court is ineffective assistance of counsel, where they go in and start studying the law themselves and they see where their attorney didn't object or present some sort of exculpatory evidence that would help them in their case, or just things like that. They're not receiving, they have to find that out after the fact once they get incarcerated and have been studying in the prison jail system, and then they're trying to get an appeal on something and have to go years and years and years to get back out. And by the time you do win your case, you still spent 6 years in prison, 7 years in prison, or something like that. I know the system is not perfect, and I know that the system, that there are people who do deserve to be in prison. I'm in no way saying that that is not true. I think we need prisons. I think we need law enforcement. I think we need lawyers, who are truly, concerned about representing the interest of their clients. I think we need all of those things. That the face of what the legal community was that was given to me in the movies is not in reality what it really is in real life. That's a Hollywood production that you're giving us on the screen. Let me read a little bit more than this. This is interesting, though. Hey, man, look, I'm glad you gave me this case. This is a fucking interesting case, though. It's interesting, the things that are being discussed here. Just reading the record. It says, but here you have, and this puts stuff into context for me. That's why I wanted to read the original indictment. I wanted to reading the original indictment tells me a lot. That's the first thing I always want to look at. What did the original indictment say? That's why I like to study how they obtained jurisdiction over something, what language they used in that announcement to claim some sort of jurisdiction over an activity. They usually do it. It's usually not directly stated. It's interesting how they get down, how they do things, but I like it. It says, but here you have regulation of something that is not commercial activity in any sense of the word, merely the possession of an item, what they call a commercial item. Your Honor, question, might we not apply a different rule in that case than we do? Give up the whole realm of commerce to the federal government? Say anything that relates to commerce, the federal government can control, securities regulation, all sorts of things. Well, but it has to relate to commerce. This doesn't relate to commerce, even. General Days, I have two responses. One, this court did decide in a case called Persault versus ICC that Congress could use its commerce powers to convert rights of ways to recreational uses for hiking trails, and there was no indication that that particular objective by Congress was a commercial objective. And this is what you're going to get also in the secret maritime jurisdiction exposed, where Valiant Liberty is talking of how they're converting rights into commercial activity. That's essentially what is going on. That's the encroachment that they're talking about. This is when you're looking at the erosion of your rights. This is socialism, the advent of socialism. This is why I'm saying I want to look at these people's nationality, because I see there's one nationality associated with communism that's at the forefront of it. And I see how the colleges have been taken over, and they're liberal institutions now of indoctrination, as well as the media, as well as all the social media. Everything is leaned toward this liberal agenda. That when you study it, what underlies it is some sort of Marxism or communism, or the seeds of a new world order. I see it. And I'm just a warning. I'm just shouting the warning. I'm just trying to help the people be able to perceive it, because they can put it right in front of you and you not see it.
And you especially won't see it if you've been properly indoctrinated. See, the point of education is to extract something from someone, to bring that person to a point of realization, to get an aha moment. That's true learning. But when you indoctrinate something, what you are doing is you're infecting that person with your personal beliefs, with your own agenda, which is nefarious once you think about it. Matter of fact, you're downright fucking devil. I had to call it what it is. Straight demon. Let's call it what it is, man. Let's call it what it is. Let's look at this. This is good. I have two responses. One, this court did decide in a case called Persault versus ICC that Congress could use its commerce powers to convert rights of ways to recreational uses for hiking trails, and there was no indication indication that that particular objective by Congress was a commercial objective. Okay, granted. But I think we have to keep in mind that the Commerce Clause, the Commerce Clause has been viewed as dealing with three areas: the channels of commerce itself, instrumentalities of commerce. But in recent years, in fact, for many of the past couple of decades, what this court has found is that activities that affect commerce are also reachable by Congress under the commerce, non-commercial, okay, you interrupted my guest question. Non-commercial activities that affect commerce. What cases do you have that involve that? Non-commercial activities that affect commerce. That's interesting. Well, it's not. Non-commercial activities that affect commerce. He repeated again. If one looks, Justice Scalia, for example, at the regulation of firearms, certainly Congress was concerned about the degree to which transfer or possession in some instances affected interstate commerce. But I think it also recognized that having a gun in and of itself is not interstate commerce. It's the impact of certain activity on interstate commerce, like using a gun, a felony, possession in the commission of a crime, possession of a gun in the commission of a crime. For example, the rules that limit the types of persons who can possess firearms is not suggesting that that particular regulation, I understand, has to do with interstate commerce. But have we ever held, I'm talking about cases of ours. What cases of ours would stand in the way of a stricter Commerce Clause jurisprudence where the activity in question is not commercial activity? What cases? He's asking, what cases do we have? What citations can you come up with? I don't believe that the issue has been clearly presented, Justice Scalia, and this is Scalia asking this question. But I think, and this is how also you can see the character of the justice. That's another reason. That's how you can decide who's a good justice and who's not, who has a certain political ideology or how they view the commerce, or who is an originalist, or who is a justice that looks at the Constitution as a living document, as it can have that it changes with the time. It changes with the time. All right, that's the two kind of justices you have on the bench, how they interpret the Constitution. You need to be aware of that. And so Scalia was an originalist. All right, so Scalia is asking them, what cases do you have that non-commercial activity would fall under the Commerce Clause? Notice again, we're talking about commercial activity. I just want to bring that to your attention. I don't believe that the issue has been clearly presented, Justice Scalia, but I think that what this court has operated upon as an initial assumption is that Congress is given the power under the Constitution to legislate directly upon private individuals, and that there was no built-in limitations on the Constitution. Okay, now we talk about public and private. They can legislate directly upon private individuals. I think we have to qualify that. Doesn't there have to be a compelling government interest? You cannot take private property without due process of law and just compensation. That you cannot make a law
that will go against contracts? I think we have to qualify that, don't we? What he just said. Can you legislate directly upon private individuals, unless you mean individuals in the sense where we're talking about corporate organizations? I don't know what you're talking about. And that there was no built-in limitations on the Constitution. General Days, just to understand what we're talking about, do I correctly understand your position to be, your rationale for this? Yes. That all violent crime, if Congress so desired, could be placed under a federal wing, could be placed in the federal court for prosecution, all violent crime, or is there any stopping point? Is there any violent crime that doesn't affect interstate commerce on your rationale? Look again, once again, what he's alluding to, that in some kind of way they have taken cognizance over some sort of violent crime because it has some sort of relation to interstate commerce. Am I reading this the wrong way? Hold on. I could be reading this the wrong way. Hold on. Let me read the comment section. Am I reading this the wrong way? And it seems like you're involved in a discussion of exactly what I talk about on this channel. Maybe you're my friend and you gave this to me for that reason. I'm sitting here seeing you argue this. This is what we're saying. Is it driving is a commercial term? It's a commercial term. Bus driver, taxi driver, limousine driver, ambulance driver. Okay, a driver is someone engaged in using the public roads for private profit and gain. Like a Uber driver. So if we're not utilizing it for those clear purposes, is there some other purpose that you're not telling us that would constitute something that could touch on some sort of commercial activity, some sort of minimum contact? That's what the people in the patriot community are asking. Okay, we see I'm not involved in commercial activity, which is obvious. Okay, but what is not obvious? What is that? Us having a driver's license? Is it us having Federal Reserve notes? Is there some sort of operational presumption that we need to rebut? That's what the American people are asking. And are you saying that the American people have no right to ask this question? Is that what you're saying? And you are a public servant, answerable to the people? It's just a question. I just got a few questions. I just got a few questions for the record. Let's put it on the public record. Let's end this. Now, let's end the debate. Let's get some questions answered. Y'all, we just want y'all to say on y'all side, fuck it. Let's explain to these motherfuckers why we capitalize everything. Fuck it. Let's just tell them. You know what I'm saying? Just do that. Just come on television and group of y'all and just say, fuck it. Let's explain it. Let's explain the significance of a marriage license. Let's just tell these motherfuckers, y'all don't need this shit. We're getting an interest in your union when you do this shit. Just start explaining shit. I'd love to see that, Just start explaining it. It sounds like it's trying to make a case for all types of civil crimes, somehow having an effect on interstate commerce and therefore defaulting to federal jurisdiction, not just civil, criminal. He said violent crimes. It ain't just civil, it's criminal too. Which there's only one cause of action under Federal Rules of Civil Procedure 2, and it's civil. Now, I don't know what that means, but it's a one form of action, and that is because admiralty is civil. It's a civil jurisdiction, but it has a criminal aspect to it. And this is what they don't want to admit. This is what Howard Freeman is discussing in the UCC Connection, which everybody should read or watch the video on my channel. The UCC Connection. Howard Freeman was another individual
when I read his work, I can see that he sees the same thing that I see. And I admire his work. He dedicated his life to giving as a thorough explanation as he could of what was going on. Another thing that I want y'all to caution everyone, I want y'all to get away from this white and black thing. Don't let that, like a lot of times when you read a lot of old patriot stuff, it was targeted toward white people. So that's why they say that the movement started with white supremacists. But that's not exactly it. The originators of a lot of this, yes, they did understand that the country was made for white people. You know, they understood that. They understood their status as a person within that society, that things did apply to them and things did not apply to them. They understood that the government had a role, vice versa, the people, that what private property rights, you know, everybody can have a gun, you know, you couldn't come and mess with nobody's guns. You couldn't come and own their private property and do nothing. You know, they understood all of that. Somewhere along the line, things changed. Somewhere along the line, the banking system intervened and got an interest in everybody's property. And as a result of that, that changed the nature of society, where everything now is predicated on some sort of commercial activity with the intention of creating money. Because money is debt. When you have debt, debt is being used as money. So to create money, you have to create debt. And everybody's coming up with some sort of creative way to do that. That's today's system. And to protect yourself, all that interest in property makes everything fall under the UCC, because the UCC is the chamber where are the rules that go against priority interest in property. When we're talking about liens, now we have to get into the discussion about a priority interest in that property. Who has the priority interest? And are you trying to tell me that you hold a superior claim against my body and against my labor? Because if you're going to make that declaration, then you're making an argument for slavery. And we know, pursuant to the 13th Amendment, involuntary servitude nor slavery is permitted in the United States. Let us know so we can formally tell you, all right, so you can't operate under any presumption that we are tacitly agreeing to be some sort of surety for the United States, or some sort of involved in some sort of voluntary servitude. Because that is allowed under the Constitution. It's involuntary servitude that's not. So if there's a presumption that we're acting as voluntary in some capacity, we're in some sort of voluntary servitude, then give us full disclosure of that fact so we can act accordingly with full knowledge. Let's keep reading this. This is good. This is Scalia asking him, okay, give me the case law that shows that the Commerce Clause can exercise some sort of jurisdiction over non-commercial activity. Now, why are we even asking that question? Why does that have to be the question? That's what I'm curious about. Why are we even talking about the Commerce Clause in a criminal action? I'm kind of curious about that. Well, Your Honor, I think that the answer is that it may be possible for Congress to do that under the commerce power. Again, one would have to look at was Congress legislating rationally? Again, one would have to look at, was Congress legislating rationally with a rational basis for thinking that regulating violence would have an impact on interstate commerce, would be the type of activity that, this is the court reporter, would be the type of activity that affected interstate commerce. Would be the type of activity, okay, let me read that again. He says, again, one would have to look at, was Congress legislating rationally with a rational basis for thinking that regulating violence would have an impact on interstate commerce, would be the type of activity that affected interstate commerce. I don't know if you were trying to say intrastate or interstate. This is just bad, what I'm reading. Okay, but I think what they're asking, would this have an impact? Would violence does violence have some sort of connection with interstate commerce? I would argue that it does. If you're a U.S. citizen, if you kill a U.S. citizen, you've affected the tax base of the country. I think that would be an undisclosed presumption that you're involved in commerce. If you have a social security number and you've elected voluntarily to be a U.S. citizen and somebody comes along and kills you, then in some kind of way, that was a laborer that was being taxed, and that affects the tax base of the country and the states, and therefore it would affect interstate commerce and would give them jurisdiction over the matter. Could that be plausible? Could that be plausible? What do you think? I'm not saying it is. I'm just saying, would it be plausible? Well, Your Honor, I think that the answer is that it may be possible for Congress to do that under the commerce power. Again, one would have to look at, was Congress legislating rationally with a rational basis for thinking that regulating violence would have an impact on interstate commerce, would be the type of activity that affected interstate commerce. But what we have in this particular act is not that bold assertion by Congress. What we have is, first of all, enough evidence to meet the test that this court has set that Congress had a rational basis for thinking that gun possession on or near school grounds affected interstate commerce. One was the relationship between violence itself and the economic activity of the country. One was the relationship between violence itself and the economic activity of the country. That's a good question. I think violence could, in some kind of way, impact commerce. I agree, but I think we need to go, a little further and look at that. What violence committed by whom, and why does it not fall up under a common law type of relationship? Why does it have to materially? If what status do you have to have, which would absolutely cut you off from allowing any type of inference that any type of violent activity that you engaged in could affect commerce? Where would that person have to be that there would absolutely be no possible way that they could affect interstate commerce? That's the question I'm asking. That's what we're saying when we're saying private, okay? What is the demarcation line that constitutes public and private? And what type of conduct would be outside of this doctrine of compelling public interest? That's the question we're asking. That's some of the things we're trying to get an answer to. We're trying to get a keen understanding of what constitutes public and what constitutes private property. And we need an explanation about communism being a political philosophy that eliminates private property. Why aren't people told that? We have all these people proclaiming the virtues of socialism and communism and Marxism, but there's no one, educating the people of exactly what that is, and that's the elimination of private property. That is the government in control of everything. That's what socialism is, which is in direct contradistinction or in direct contrast of the spirit of intent of how this country was formed as a Christian country, as a free country. You coming in and you trying to undermine the foundations of what the country was established as a free country and as the ultimate example to the rest of the world of what a free country should look like. And you in here busy undermining all of this, making a mockery of the country, having transgenders in the government, making us look like a nation full of punks. Our women can't respect us, so they acting out.
Man, come on, man. Y'all don't see what's going on. Y'all better wake up. It's time for masculinity to rise again and reassert itself. How can you be a man of integrity, be a man of principle if you don't have any boundaries? There has to be a line no one can cross. And in all due respect to the other party, I need to know what the limits of your rights are. Because that's what being sovereign is about. The ability to do whatever I want to do as long as I don't encroach on the private rights of another. And that includes government. Government has rights. I recognize that. But let's clearly define what those are, using a basis for that as the Constitution, because that's what creates government and also restrains government. And we know that the Constitution falls under public laws, not private. It don't have anything to do with private individuals and their private rights. You're reading the government's weak arguments attempting to stretch the Commerce Clause power. I'm reading the government. Well, they made the argument. Yeah, I'm reading it because it's interesting that the government is even making this argument. Why are they making this argument? They're making the argument because they understand what I understand. It's the Commerce Clause. That's where they derive their power from. And you have to understand separation of powers to understand the plenary power doctrine. These are things that I read and I understand. Don't you understand them? You've been an attorney for 40 years. Clearly you understand what I'm talking about. You have to. So, yeah, I'm going to read it because it's a proper argument. It's not a weak argument. That's a proper argument. Scalia understands their delegation of powers and the extent of their authority. That's why he's asking, where's the case law? Oh, don't you know you don't know what you know, but I'll bet that you think that you know. But if you really knew that you don't know, you know, then you already know what I know, you know. That's in dealing with presentments. You know, that was in dealing with presentments. I have a version of that on dealing with presentments. I have a version. I forgot the name of the author of it. You just make me want to look it up real quick. Look how fast my website is moving now. Oh, it's going lightning fast. Man, I had to find out, you know, the website, if you came over there, was moving slow, but I think we got that hurdle taken care of. Now it's moving lightning fast. I'm loving it. Right here, dealing with presentments. Let me see if I can find it. Where is that at? Is it possible? I like this one right here. This is where you always hear me quoting this. As to methods, there may be a million and then some, but principles are few. The man who grasps principles can successfully select his own methods. The man who tries methods and ignoring principles is sure to have trouble. And this is why I listened to that. I think it was Judge Iredale, one of the original Supreme Court justices. He gave a speech before an audience of students in Philadelphia, I believe. I can't remember if it's the University of Philadelphia or not or whatever. I think it was in Philadelphia. And one of the students asked him that the law was very vast and how could they study all of it? And his response is, you don't need to read all that. You need to study the principles. And that's why, because there are a few principles. But those principles have application to a million different methods.
And that's why the judges study principles and make their decisions based off of principles. Because people out there are using different methods, and the judges are using principles to adjudicate on their actions, and then obtain a certain set of facts so a law can be applied to it. But you got to study principles. It's principles you got to master, principles of law. That's what you got to master. I like this right here. Change your thinking. If the thinking perceiving ruts in which you have been confined, and then alter, revise, and expand them. Cast your nets on the other side of the boat if you're not catching any fish on the side you have hint to before fishing. And that's what he was telling everybody on, he's giving you some direction when you when you get into this information. Where is that thing? He got me one. Yeah, here it is right here. He says, we think so because other people think so, or because after all, we do think so, or because we were told so and think we must think so, or because we once thought so and think we still think so, or because in having thought so, we think we will think so. That was Henry Sidgwick. Lines composed in his sleep, quoted by William Osler, South Pacific Magazine, 1907. I like this. It was Sidgwick. We think so because other people think so. We do. I think this was really appropriate in this. But that's what I was looking for right there. That's what you made me think of when you just posted that. I was thinking of that. I like to say, he who understands the principles of a thing cannot be fooled by the circumstance of the thing. He who does not understand the principles can speak only to the circumstances, and that's absolutely correct. When you don't understand when you don't understand the principles, when you understand the principles, you can't be fooled. That's why the principles of life is understanding natural law. Once you understand mentalism, correspondence, vibration, polarity, rhythm, cause and effect, and gender, then nobody can fool you anymore. They can't fool you with religious indoctrination. They can't fool you with all this bullshit. There are more than two genders. That goes against a natural law principle. That argument dies on its face once you understand natural law principles. Everything in creation has a masculine and feminine aspect associated with it. Everything in creation is dual in nature. Up and down, hard, soft, light, dark, right, left, up, down, in, out, day, night, public, private, hot, cold. Once you understand principles of natural law, you can see how they're trying to make a mockery out of you. How how stupid some of the arguments that the liberals are making, and how insidious it is to persist in trying to indoctrinate people with it. They are godless. And by that I mean they have no observation of nature whatsoever, because nature is the example of God. The only evidence of God is nature. So they abhor nature. Everything is unnatural that they're engaging in. Is it natural for you to abort your babies? And what creature does that at the rate that human beings do? The only reason your marriages are failing out there is because they came up with this way, these birth control. If it weren't for birth control, women be having all kind of children. Ain't no way they be trying to leave their husbands and go out and live their best life and do all these things that they trying to do. They undermining the traditions of the country, which have a religious basis attached to it, which when you study the Communist Manifesto, that's one of the pillars of the Communist Manifesto, the destruction of religion, the elimination of religion. That's why you're seeing every single person making the arguments that they're making. If you bring up God, you're going to be criticized. You're going to be attacked. That's how you find out their mindset. You say, okay, I'm dealing with a communist. What's wrong with that? Oh, I get it all the time. I would say, oh, you're a communist. You're a socialist. Tell me one thing that's wrong with socialism. It goes against natural law. It goes against the law of attraction. That's some made up, oh, you believe in a sky daddy.
This is how they argue. And I'm not talking about no sky daddy. That's why I'm always harping on natural law, because natural law is something that's evident. It's self-evident. Anyone can recognize it. They look like a fool arguing against it. You look like a fool arguing against gravity. And you say, ain't no gravity. I take your ass to the top of a building and push your ass off. Let's keep going. I want to go back to this. All right, it says, one was the relationship between violence itself and the economic activity of the country. To the extent that there is violence in certain parts of the country, it makes it difficult for institutions to function. Okay, so I guess that's how it affects interstate commerce. If there's violence in that section of the country, then this institution can't function properly. There is the insurance consequence. Where violence occurs, insurance burdens are shared by the entire community, not just by the locale where this particular violence occurs. Now we're getting an explanation of how certain non-commercial activity could affect interstate commerce. It interferes in the same way that this court found in Heart of Atlanta Motel with respect to the travel of persons in the face of segregation in places of public accommodations. It interferes with and notice we're talking about a business. It interferes with the willingness of people to travel to certain parts of the country. Okay, it affects the travel industry. They're explaining it. This is some of the best explanations I ever read that I've seen in the public in a case. And I'm not reading the case, I'm reading the stenographic record of the proceedings of what was actually said, the argument, as he liked to say, in court that they were making. This is very enlightening. Thank you. I'm gonna make sure I put this on my website and everybody can read it for themselves, because I'm sure I have some extremely intelligent people who are more intelligent than me that would be interested in downloading this and sharing this with their study groups. Let's see. Where there is violence present, yes. Question, may I test a different way of reading the congressional rationale? What if Congress had said, as part of its thought process expressed in the amendment, that the states, for whatever reason, violence or whatever reason, had simply proven incapable of providing sufficient education in math and technology that in the long run was a threat to commercial activity, and as a response to that, Congress was in fact going to nationalize the schools, and it in effect could provide a federal public school education for every child from kindergarten on up. Damn, that's something that is within the realm of possibility. That is completely plausible. That is completely plausible that could occur. Would that be justifiable under the Commerce Clause? General Days, well, that's certainly one of the concerns that's been expressed, but I think that this court is readily available to it a way of analyzing that, and that in reading New York versus the United States, one would have to be concerned whether this particular activity was imposing statutory requirements on the state, or when you say statutory requirements, are we again referencing the Commerce Clause right there? When you're using that term statutory requirements, are we saying that your statutory requirements are about commerce? That's what we're asking. You know, we're asking, like when we ask the question in court, when we say, how does the defendant plead? Well, Your Honor, I'll be more than happy to enter a plea into the record. But first, before we do this, I think we need to address the question about my status before this court and the jurisdiction of this court. Now, am I correct in my understanding that the Constitution for the United States of America, pursuant to the Sixth Amendment, protects my right to know the nature and cause of any action? Yes or no, for the record? He should say yes. Okay, thank you. My next question is, it is within the purview of this government, pursuant to the Constitution of the United States, that it is granted only two criminal jurisdictions. One is under the common law, and the other constitutes a condition of contract and the criminal aspects of a colorable admiralty jurisdiction. Now, sir, for the record,
Would you please tell this court and myself under which two of these criminal jurisdictions this court is trying this criminal action? Now, I know it's a lot of you attorneys are probably watching this, and this is a question that never gets answered. Now, I know you have a lot of fancy ways of trying to, in some kind of way, be comical about the question. But why are you being comical about a private right that is in the Constitution? You should take that deadly, shouldn't you be serious about that when we say that? I've never understood that, how people, when they pose that question, that in some kind of way is turned into some sort of mockery. I ain't made the connection on that yet. I can only assume that in some kind of way you're operating in some sort of treasonous type capacity. You know, I think you're gambling. You're gambling on the fact that the American people ain't going to wake up and truly understand what is going on. I think you're gambling in a lot of cases. You think everybody's stupid. This is interesting. So I was just wondering what you mean by statutory requirements. You know, if it's common law, that will require a corpus delicti or an injured party with a sworn out complaint that under the Sixth Amendment I have a right to face my accuser, or it's some sort of contract, okay, which is required under an admiralty jurisdiction for you to take cognizance of that particular matter. That had to be some sort of contract. So don't we have a right to know the answer to that question? And if there is another jurisdiction and it is not mentioned in the Constitution, can you give us an explanation of how that activity is granted, or some sort of authority is granted to you to have this jurisdiction pursuant to the delegation of powers received from the Constitution? Because if you can't show me that, then you're acting outside the ambit of your delegated authority, and that makes you susceptible to a private claim because you're acting privately now, not under the immunity cloth of the Constitution or some sort of delegation of powers coming from one of the main three branches of government. Where are you getting the authority? The quo warranto. Where are you getting the authority to make up a new jurisdiction and pull it out of your ass and subject people to it? That ain't mentioned in the Constitution. I don't know where they came up with that word sovereign citizen. I don't know where to me, when they say sovereign citizen, it's like them saying nigger. That's how y'all should look at that word to me, because I've never seen that word in case law in any way with reference to the American people. But I have seen the word sovereign, and we can start with Chisholm versus Georgia, which is the first Supreme Court decision, where that was the discussion, the sovereignty of the state of Georgia against the sovereignty of a private individual, and they found that sovereignty rests with the people, not with the government. So I think it's very disrespectful. I can only assume that if you're an attorney out there calling people sovereign citizens, I can only construe that you're some sort of communist or Marxist. You're some sort of liberal. That's how I'm looking at it. And that's why I want to know your nationality. That's why I'm just giving you the chain of thought that I have, but as a result of my research, when I encounter certain individuals who have a certain position and I can't understand why they have that position, it doesn't seem that they're revealing it to me, that I'm going to question things about them. And so I'm gonna look at, okay, well, why is it that you're coining this phrase sovereign citizen? I ain't never seen that nowhere in law anywhere. Why is it that we can't have a discussion about Chisholm versus Georgia? Why I can't see, I don't see people, I have to be the one to make a video about it. I have to bring it up. I got to be the one to do all this and get attacked. Oh, yeah. And then as soon as I do it every single time, I don't know what I'm talking about. Just every time, I don't know what I'm talking about. It says, I would agree. There is no definition from a dictionary or otherwise that I've found. I haven't either. Because it's not a word. It is not a word. You can't be sovereign and a citizen. I don't understand what's a sovereign citizen. I know what they're trying to say. They're trying to say I'm sovereign, but I'm a citizen of the republic. That's what you really are. You know, before the 14th Amendment, they had state citizenship. That's why in the Constitution, when you see the word citizen prior to the 14th Amendment, it's with a capital C. After the 14th Amendment, it's with a lowercase c, because we're talking about two different kinds of citizenship. We're talking about a federal citizenship versus a state citizenship, because the states are the ones that gave the delegation of power to the federal government, and they are subject to that delegation of power. There's certain powers we granted them and certain powers we kept from them, like you would do in any type of trust arrangement. That's why people call the constitutional trust and the government officials trustees, because that's exactly what they are. They're trustees of the powers of the true sovereigns, which are the American people. I'll give you an example of that. If you go watch the movie Gladiator, in the beginning with Marcus Aurelius and Maximus, and he's bringing him in, having a discussion with him. And he says, you know, come Maximus, let's talk as men do. And he just wants to know about his family and what kind of man he is. And then he hits him with a proposition. He said, I want you to be the defender of Rome, or the protector of Rome. He's calling him a protector. And then Maximus said, I'm not educated. I'm not a politician. He said, no, but you're a good man. See, that's the quality that you need to be a protector of something. You have to be a good man. Okay, that's the quality you should look for a trust protector of your trust or your trust estate. Okay, because there's something called a trust protector. So that's what he was telling him. Because then he later on in the movie, when he's talking to his son, he's telling his son how he's not going to be the emperor of Rome, that he was going to put his powers in trust and turn Rome back into a republic. All right, it's going to be representative of the people. So his powers are in trust, and the senators are acting as the trustees. Well, of course, the senators are a den of vipers. So he's asking Maximus, will you be the trust protector of it? Will you be the person, because the trust protector can remove trustees. So he's giving him power over the Senate, which is the people. We're the trust protectors. In the United States of America, they gave that position to us. We are the ones that have the authority, through the right due process, of course, to remove public officials with what they call the democratic process. But you know, that shit can get hijacked the way that it's operating right now. Federalism is something doing with the federal government, which I don't know if you're agreeing with me or not. I understand federalism. Just by the name itself, it's an ism. It's an ism. Yusuf got me opening my eyes to all those people's nationality and their intentions. That's right. Facts, Yusuf, that's exactly right. I've heard citizen has a Latin origin meaning city servant. A servant would be antithetical to a sovereign. Exactly, but what they're saying is that they're in some sort of social compact. This social compact that denotes that you're a citizen. It's like a social contract that you're in, okay, which I agree with. I agree with the social compact, because the good of the many in certain respects should outweigh the good of the few. You know, when we come together as a society and agree to engage in a commercial activity with each other, and because man has proven in history that he's not always going to act honorable, then we need a government. We need a government to come in and, you know, be a mediator in that activity. And as such, they're going to request some remuneration for that service, which they will call a tax. That's why I don't have a problem with public taxation. I understand its purpose. I don't have a problem with taxes. You know, you're not going to hear me be a tax protester, because I understand public and private. I got an understanding of it. You know, I like to style myself as a businessman, not the best businessman, but I'm striving to get there. And I understand that all this is business. And the people who don't like it are the people who don't like business. That's why Colonel Mandelhouse stated, there's a quote from him where he says that the people who don't understand the system are going to hate it, and the people who understand it are going to love it.
That's the reason people feel like they're being oppressed, because they don't understand how the system operates. But once they understand the rules to the game, hey, they can play the game. Now we on equal footing. Now I say, oh, okay, this is how you play the game. Like when I first learned the credit game. When I understood how to play it, I'm like, okay. I was operating under a different assumption about credit. But once I understood what the purpose of the game and how it's played, I have a whole different perception of credit than the average person out there. How they're looking at credit. They just look at credit and get something or not. I understand you leverage credit. You build credit to leverage it. You have to leverage your credit. That's the skill that you're learning how to do. Not buy shit and then pay shit off, even though that is one aspect of it, but it's not the only. It only makes about 33%, We don't need government in the way that it's currently constructed. It looks like we need to tear it down and rebuild. I don't know about that. I think that we just need to be more, the way that it was set up is a good way that we're setting it up. It's just the people are ignorant. And once we regain our knowledge about the government, how government is properly function, we can just, through the voting process, put the proper people in. See, what's happening is you're sending your people up there, and Jesse Ventura said this, and I remember in an interview, he said a lot of people, when they get elected, have very, very good intentions. He said, but when they get up on Capitol Hill and they look behind the curtain and they see how things are really ran, sometimes they lose hope. But a lot of them I look at, I be wondering, I watch them on YouTube, and I think they really love the country and they really trying, but they got an uphill battle. But then it's really hard to say if they just acting or not. Because when you see somebody like Cynthia Tucker, she said that everybody out there, they got to sign some sort of pledge to Israel. If all of them made that pledge to Israel, but then in the public, they look like they having contentions against one another, like James Traficant said, but when it comes to the issue of Israel, they all on the same page. It makes you have to question where their allegiance lies. Does it truly lie with their constituency or to some foreign power? And if it lies with a foreign power, how is that materially affecting legislation in our country? I think it is a question we need to ask. I think we need to explore that. There are some similar philosophies that we share. Okay, John, I'm not your enemy, Juan Galt. I'm not your enemy. I'm not your enemy. I'm just trying to get to the truth. But as a warrior for the truth, if anybody gets in my way, I gotta steamroll them. I just gotta steamroll over them. I just gotta keep cutting it. That's what it's called, the double-edged sword. It cuts up lies. You gotta cut up the sword of truth. You had to S to the word word, you get the word sword. It's a sword of truth. Through words that cut up lies. You got to cut up these lies. It's time. We had a crossroads. It said the whole world will know the truth and then the end will come. The people have to know what the truth is. And the only vehicle that the creator of the balance can utilize to get the truth to the people is some other man or woman. God blesses people through people. And you should be a blessing to someone. Give in order to receive. You want to make the world a better world? You need to start returning back to some of the principles that are enumerated in the Bible. Reestablish your families. What are you talking about overturning the government? You don't even have your family life together. How you going to clean up somebody else's house and you ain't got your own goddamn house affairs in order? You don't need to be talking about the government until you get your home in order. How can you talk about getting the government together and you don't even make up your bed in the morning when you get out the motherfucker? And your yard look like shit. Your neighborhood look like shit. Voting is the only activity you engage with the government in which you can't get a record of evidence to take to a jury or judge ensuring it's accurate. And I said that too. with that last election. I was like, well, why we don't just use computers? All you have to do is take people's social security number and associate it with one vote and make sure that everybody with a social security number and that can be proven in the database that they are alive, okay, and not dead, okay, and that they are a U.S. citizen like y'all like them to be, then, hey, why can't people vote through the internet? I don't understand that with all this technology. Why do you have to go to a voting poll? That's an antiquated method of doing a vote. Why can't it be shown in real time? I'm talking about in real time through the internet. The technology is there for that. It's been there for that for the last 20 years. There are enough security measures in place. Try to go to the government website and get access to something without your social security number. If they can do that at the IRS website, they can do it for voting. He said, I declare war on you. He said, I declare war. Hey, I'm reading what's being said right here. I don't see the argument. I don't see this right here is great. I'm not going to read this whole thing, but I'm reading this 51 pages, but I'm going to sit back and read it off the air because it's a good educational tool right here. I thank you. I truly thank you. I'm glad I looked this up. I looked this case up because it's this argument that you're making in court that's very, very revealing. I think you will agree. I think you will agree. It's very, very revealing. This right here is very revealing. Hey, look, y'all, I'm going to get off. I'm going to come back tonight. I got to do another show. I got to do some consultations, but I'm going to come back and I'm going to do another show. It's going to be today. But y'all watch this and y'all study this. All right. Peace to the gods. Like, comment, and subscribe. And I'll see you on the next live.